days of today. I'd like to welcome Secretary DeVos and thank her again for appearing before the committee. I'll now yield to the gentleman from Michigan, Mr. Wahlberg, who has requested the honor of introducing the Secretary.
I thank you, Mr. Chairman, for your deference to allow me this opportunity. We Michiganians are proud people, and I know there will be disagreements here in this hearing today about what the Secretary is doing, but having had the privilege and honor of knowing her and her family going back into the early 80s, and knowing the impact that her family, as well as the family she married into, has had in not only Michigan, but all across this country, not because they were pushed into it, but because they had a passion for seeing young people educated from K through college, and to make sure it was done in appropriate ways, and that people have had choices that wouldn't have had choices before. They've done it in a way that has made a difference, and it continues on into their children as well, in cultural areas, educational areas, manufacturing, bringing up people that would not have had the opportunity that they had. So I understand this will be a challenging hearing today. I do know from personal experience that our Secretary wants to do things right, wants to do it according to law, wants to make sure that things are carried out on both sides of the ledger, and especially that students and taxpayers are treated fairly. And I know that because of knowing how she and her family have carried on the life in Michigan and touching lives who would not have been carried on in a way before that led to success. So I just want my colleagues to know that background information as well, even though she is the Secretary of Education and is entirely capable of answering all the questions we have. I welcome you and thank you for being here.
Thank you very much. Before you begin your testimony, Madam Secretary, I'd like to acknowledge the presence of retired Air Force Major General Mark Brown, Chief Operating Officer of the Office of Federal Student Aid. For agreement with the committee, General Brown is here to assist the Secretary in her answers. He is not a witness at this hearing. In the course of answering a question directed to her, the Secretary, according to the agreement, may consult with General Brown or direct him to assist her in the response, but insofar as he is not a witness, members are reminded that questions, including follow-up questions, may not be directed to him personally, but must be directed to the Secretary. Let me remind you, Madam Secretary, that we've received your written statement, and it will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, you're asked to limit your oral presentation to a 5-minute summary of your written statement. Pursuant to Title 18 U.S. Code Section 101, you're aware of that code section prohibiting false statements to committees, so we'll forego the spectacle of the swearing in. Therefore, before you begin your testimony, please remember to press the button on the microphone in front of you so that it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green after 4 minutes. The light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we'd ask you to wrap up. During member questions and answering a question, please remember to once again turn on your microphone. I now recognize the Secretary of Education, Secretary DeVos.
Thank you so much, Mr. Chairman. Thank you, Congressman Wahlberg, for that very kind introduction. Chairman Scott, Ranking Member Fox, and members of the committee, let me first thank the committee for its willingness to make this a productive hearing. We have provided the committee 18,000 pages of documents during the past month on borrower defense alone. We have briefed you several times, and I'm hopeful we can use today's hearing to continue in that spirit of constructive dialogue. Let me also thank you for the opportunity to set the record straight on this administration's approach to borrower defense to repayment. I want to be very clear. Students are my #1 priority. They are why I come to work every day. So if students have been deceived by institutions and suffered financial harm as a result, they should be made whole. But if claims are false or students did not suffer financial harm, then hardworking taxpayers, including those who scraped and saved to faithfully pay their own student loans, should not have to pay somebody else's student loans too. It's a matter of fairness. Adjudication of these claims must treat all students and taxpayers fairly. Simply discharging all of these loans, as some on this committee suggest be done, is not fair to taxpayers nor to those who have paid or are paying their loans. This administration's commitment to fairness and the rule of law continues to guide our thinking with regard to borrower defense. When borrower defense arrived in 1995, it was a regulation in the Higher Education Act that was little known and little used. In fact, in the 20 years from 1995 to 2015, fewer than 60 claims were filed. Then the previous administration weaponized the regulation against schools it simply didn't like. They applied the law in a discriminatory fashion. So since 2015, there has been a 5,000% increase in borrower defense claims. This administration is committed to pulling back the previous administration's overreach and will enforce a borrower defense rule that is consistent with Congress's intent, that protects all borrowers, and that treats taxpayers and schools fairly. Before I discuss the important distinctions of our borrower defense rule, let me begin by saying what it does not do. First, it does not apply retroactively. When our rule goes into effect on July 1st next year, it will apply only to loans first disbursed after that date. This means that the department will continue to enforce, in good faith, the previous administration's 2016 rule for all loans disbursed between July 1st, 2017 and July 1, 2020. Second, our rule does not shield any school from accountability, nor does it relax oversight of bad ones. All institutions, no matter their tax status, are held accountable under our rule. Finally, our rule does not demand that students prove that their school intentionally deceived them. Instead, the rule provides due process for all parties. Our process focuses on individual students and requires evidence from both the borrower and the school before deciding a claim. And unlike the prior administration's rule, the student always has the opportunity to respond to the school's case. Now let me discuss the basics of what our rule does do. First, our rule puts into place a process that is clear, understandable, and easily accessible for borrowers. It also ensures that claims are processed efficiently, carefully, transparently, and fairly. Second, students may file either affirmative or defensive claims, all of which will be judged using a preponderance of the evidence standard. Third, our rule provides a legally grounded, reasoned, and appropriate definition of misrepresentation. It enables both borrowers and institutions to present evidence, obtain relevant evidence we're considering in the case, and respond to any evidence in the record. These reforms constitute much-needed course corrections to the 2016 rule currently in place. The Obama administration's rule punishes for-profit schools, but gives nonprofits a pass for the very same conduct. Now let me turn to the ongoing adjudication of existing claims before the department. Yes, there is a backlog of borrower defense claims at federal student aid. To say that I am frustrated by that is an understatement. But rather than focus on why there is a backlog, too many have instead focused on creating more chaos and a circus-like atmosphere. Here are the inconvenient facts about borrower defense. First, we inherited from the Obama administration more than 64,000 borrower defense claims. So I asked the IG to investigate why they had made such little progress processing these claims. The IG found material weaknesses in the previous administration's procedures for approving and denying claims. In fact, the prior administration was encouraging claims to be filed, knowing full well it lacked the ability to even accurately track them. It had no process in place for reviewing any claims, and it knew that the department couldn't quickly and legally give blanket forgiveness of all loans. So when they left office, they left tens of thousands of claims behind. Greeted by this crushing number of applications and without effective guidance from Congress, we took action to establish a process for reviewing the backlog, using the prior administration's categories as our baseline. We quickly adjudicated 32,400 claims. Our relief methodology was based on the same data, Social Security Administration data to be exact, that the Obama administration used to measure schools under their gainful employment rule. Unfortunately, in May of 2018, a federal district court in California determined that using that data violates the Privacy Act. We strongly disagree and have been waiting for a decision on appeal from the Ninth Circuit for well more than a year. The department stands ready to process these claims. I want to process these claims. We simply need a decision from the court. In the meantime, we're doing everything we can to process claims in another manner. I recently approved a new scientifically robust methodology that relies on publicly available 2017 gainful employment earnings data, Social Security Administration earnings, college scorecard data, and IRS information to determine harm and calculate the amount of relief. Ultimately, what the department wants, what I want, and what taxpayers deserve is to provide fair relief to all those borrowers who actually have been harmed. That is what the law requires. That is what you intended by the Borrower Defense to Repayment Law, and that's what we're doing. Thank you. I will be happy to answer your questions.
Thank you, Madam Secretary. Under Committee Rule 8A, we'll now question witnesses on the 5-minute rule. As I mentioned earlier, as chair, I've decided to go to the end, so I'll yield to the next senior member, the majority side, who will be followed by the ranking member or her designee. We'll then alternate between the parties, and I remind members again that all questions are to be directed to the secretary, who can consult with General Brown, and I'd also remind members that the subject of the hearing is borrower defense. Per our agreement, members should limit their questions to that issue. I now yield 5 minutes to the gentlelady from California, Ms. Davis.
Thank you, Mr. Chairman, and Madam Secretary, welcome. We're glad that you're here. In the course of our discussion with you today, I hope we can determine your interest and your thinking on this issue. One of your roles, of course, is to protect the taxpayer, but we hope you will also want to protect students from the harm caused by predatory for-profit programs. Today, you are here to get credit, I think, for the new partial relief formula, but it does deny full relief to the vast majority of defrauded students. Can you tell us how many partial relief funding formulas you discussed with your department before settling on this one?
Well, thank you, Congresswoman, for that question and for your continued concern about and focus on students. We share that concern and want to do what's right for all students. We considered a number of different methodologies once the court shut us down in May of 2018, and we wanted to make sure that we had a scientifically robust and defensible approach to being able to determine whether a student was indeed financially harmed. And we believe that this new methodology addresses those concerns and will indeed treat and consider each student and their individual circumstances very fairly and straightforwardly.
But I think you must be aware that the new formula does rely on incomplete earnings data, which represents only about 20% of all programs. Would you agree that that's incomplete?
Well, it relies on a number of different data sets, and it's all publicly available. It is all, it is actually more expansive than just the gainful employment data, and it is taking into consideration programs at schools at which the student has filed a claim versus programs like programs across the country.
Well, I certainly hope you'll look at that again, because the 80% of all borrowers only includes borrowers who completed degrees. And most students seeking relief under borrower defense don't complete their degrees. So I want to read to you a quote from a story which came from the recent NPR story. Are you familiar with that story?
I've heard about it. I haven't listened or looked at it in depth.
Okay, and I believe that was one that really had to do with the work in your department. And I quote, "I was also told by the recruiters from the school," and this is a student speaking about what happened. "I was also told by the recruiters from the school about wages I could make that I have yet to be able to earn due to the fact that the school is and was not very credible. The ITT Tech recruiters assured me AA students graduate making around $50,000 to $60,000 a year, and a BS graduate would be around $80,000. So they misrepresented their product, their name brand, and their education. Would you say that student has been harmed?"
I'm not going to comment to hypotheticals. I am sympathetic to that student's plight, and if that student has filed a claim, it will, of course, be adjudicated and processed appropriately through our efforts at the department and FSA.
Well, does the university not have a responsibility to provide what it claims it will? There is literally no other consumer protection that does not restore full repayment of a fraudulent product. We're all aware of that. We've probably been through it. NPR reported yesterday that internal memos in your own department show that career staff advocated for defrauded students to receive full relief from borrower's defense. Did you review the memos that came from your own department?
I'm not sure which memos to which you're referring. There are lots of memos generated within the Department of Education. There are hundreds and hundreds of lawyers, and many of them have lots of opinions. So if you'd like to share the specific documents, I'd be happy to review them.
I believe there were thousands of them, and I'm just wondering, I mean, according to the report, the majority of career staff disagree with you, and so that was clear in the report, and I'm sure you'll have a chance to have a look at that. I think there's also, a concern. I mean, if you weren't listening to the career staff that were telling you that what they were seeing was students that were definitely harmed, but did you rely on that same staff for the partial defense plan that you came up with?
Well, Congressman, what I know when I came into my job is there were tens of thousands of claims, and there was no process and no structure for actually considering them. We worked on and developed a process and a structure, implemented it, and we're well down the way of considering all of the claims that we had pending, and then the court shut us down. We had to develop another process. We're still waiting for the court to opine on the ruling that they made in May of 2018.
Thank you. Mr. Chair, my time is up. I was also going to go into the Federal Trade Commission coming up with the University of Phoenix ruling. And the interesting thing about that is that if students had a federal loan, they will probably not be made whole. But if they got their loan through the school, they will, which is an interesting dilemma that we're going to have to face. Thank you, Mr.
And lady's time has expired. Dr. Fox.
Thank you again, Mr. Chairman. Secretary DeVos, it's important to conduct good oversight, and to do that, we need to have a good working relationship with the department. I know you're trying to cooperate with congressional oversight, so thank you for those efforts. Madam Secretary, I know there are several letters that you have received from the chairman that his staff has also sent a significant number of emails with additional requests. Is that accurate?
Yes, it is.
My understanding is that you're diligently working to address those requests. Is that correct?
Yes, it is, and we have been, for sure.
More generally speaking, how many letters have you received from Congress since taking office, and what is your overall response rate?
Since I took office, on average, we receive 1.8 letters every day from members of Congress to address specific issues. We have responded to 95% of those letters, and I have placed a high priority on making sure we are responsive and timely in our responses.
So 1.8 letters per day
Per day,
from members of Congress.
yes.
So moving on to borrower defense, these questions might require more technical information, so I'm fine with General Brown sharing information with you to answer the question. There's a report the department issued before you were there that claimed FSA was on target to clear all eligible borrower defense claims by spring of 2017. Are you familiar with this report?
Yes, I am.
Do you know how many claims the administration had processed at that point and how many remained then?
I believe there were 16,000, General Brown, was it 16,000 that had been processed before I came in? And
16,000?
16,000, and there were 64,000 awaiting me when I came.
Okay. So could you tell us why you were not able to clear pending claims by spring of 2017?
Well, as I mentioned in my opening comments, there was no process in place to actually consider the claims. The ones that had been processed early on were clearly ones that that there was 100% relief involved, but as more of those claims were considered, they continued to deteriorate, to use the federal student aid terminology, in terms of their validity of claim. And so without a process in place, we had no way of actually determining what the relief could or would be.
It sounds as though from the information that we've been given and things you've either said or alluded to, it was as though the Obama administration just okayed every single claim if there was no process. Is that an accurate thing to say? So it wouldn't have mattered what the students said, but they just said, I want my loan forgiven, and it was forgiven.
Yes, that is based on the data that we've seen and the information that we've been able to find from that time period.
So no proof was required of the students that, a student, that he or she actually had been defrauded.
No, once again, there was no real process in place. So it was a matter of looking at claims and then forgiving them. And that had been done for a number of thousands of students before I arrived.
Right. There much has been made about the, quote, career staff, end quote, who made some recommendations to you early on about how to handle these claims. My assumption is those would have been the same career staff that had just been simply sending out forgiveness for loans to these people. What is your understanding of your role when you get a recommendation from a staff person?
Well, I get many recommendations from staff, both career and politically appointed staff, and take them all into consideration. I clearly understand and acknowledge the expertise of those who've been in the department for some time. But in this case, for one thing, I'm not sure what documents are even being referred to, so I don't want to comment on specific documents when I'm not sure what they exactly say. And secondly, like I said, there are hundreds of lawyers in the Department of Education, many of whom generate lots of ideas and lots of recommendations. And I take those. I don't review all of them. Some come to me, but I take the recommendations, I take the input, and ultimately, I need to make sure I'm following the law and that I'm establishing policies and practices that are consistent with the law.
Thank you, Madam Chairman. Thank you, Mr. Chairman. I apologize for going over.
Okay. Gentleman from Arizona, Mr. Grijalva.
Thank you, Mr. Chairman. There's no question the Corinthian borrowers were defrauded, and that fraud was so severe that they were entitled to full relief. In fact, the Department of Education found that Corinthian education provided little or no value. Madam Secretary, do you agree Corinthian defrauded students?
Congressman, I know that there were a number of students that attended Corinthian programs that have claims for financial harm based on their experiences and their individual circumstances. And we are continuing to work to make sure that those claims are ultimately processed and those students are responded to. Again, unfortunately, the courts have stopped our processing of those.
But there has been countless memos developed by your own attorneys in the Department of Education about the wholesale defrauding of students by Corinthian. And in fact, the court filings by over 20 state attorney generals would disagree that this is a widespread issue. But do you agree that Corinthian misled students on the college's graduation rates? They falsely asserted a degree would result in a guaranteed employment, and that academic credits from Corinthian would be accepted and transferable to other colleges. Do you agree that those students were misled?
I think in some cases that was probably the case, but I also know that the prior administration basically forced schools like Corinthian out of business They put financial restrictions on Corinthian that didn't allow the school to even continue operating anymore. What we need
But
to
the
do.
fundamental question with Corinthian, you can agree or disagree, and I'll ask, that Corinthian provided no educational value to its students as a result of fraud, and that was pervasive before any discussion by any administration regarding that program.
I don't agree with that narrative. I think there are many students that received valuable education from Corinthian, just like they do from many other institutions. The
Referencing the-
question is, what students among them were financially harmed?
Well,
And
referencing
that
the
is
same
part of the
NPR story
process.
that my colleague, Ms. Davis, referenced from yesterday, the Internal Communication in the Department of Education from January 10th, 2017 concludes, given this extensive, well-documented, pervasive, and highly publicized misconduct, the department has determined that the value of an IT&T education like Corinthian is likely either negligible or non-existent. Accordingly, it is appropriate for the department to award eligible borrowers full relief. So, do you agree that those loans before July 1st, 2017 are subject to the Borrower Defense Fund standard?
They certainly are subject to the borrower defense rule, but they're not subject, or they are not automatically subject to full and complete forgiveness of every single loan.
Okay.
That is, I mean, even the prior administration individuals acknowledged that there were up to 40% of the Corinthian claims filed that weren't even eligible for consideration. And so,
But the
again, I go back,
1994
sir, I'm sorry, I
standards,
go back to the
Madam
fact that there
Secretary,
was no
I have
process.
limited time.
There was no way to really consider these claims. I inherited no process. We had to create a process
but
and
the
construct a
1994
process.
standard-
I understand that some of you here want to just have blanket forgiveness for anyone who raises their hand and files a claim, but that simply is not right.
No, I think most of us here want justice for these taxpayers that happen to be borrowers, for them to receive the relief that they need to receive. And the 1994 standards established that these claims are subject to state law standard, meaning those 20 states that found that the college engaged in fraud, those students are entitled to borrower's defense. And how many of these loans, pending loans, fall within that criteria of the loans that you're talking about, that we're talking about with Corinthian, and that are seeking relief from the department? It's a question.
Is that a question?
Yes.
I don't have the specific number of Corinthian claims that are still pending. Perhaps General Brown can help us.
Well, I think, Judge Kim in her decision said, this is a problem that the government created, Madam Secretary. You have an obligation to provide relief to those borrowers regardless of cost. Do you agree with that?
We have an obligation to follow the rules and to follow the law, and we have implemented a process that will actually allow us to do that. We had implemented one. The
Well,
court,
in the
the
defense
court
of-
didn't agree with the
In the
data we were
protection of
using.
taxpayers, we have to agree that those seeking relief are taxpayers, and the department should be doing something about protecting them as well. Thank you, Mr. Chairman.
Thank you, and I'm going to have to be a little stricter with the time because we may run over. So with that, Dr. Rowe, you're recognized.
Thank you, Mr. Chairman, and thank you, Madam Secretary, for being here and your work on simplifying the FAFSA form. And General Brown, thank you for your service, sir. Today, Madam Secretary, I'd like to discuss your authority when it comes to awarding relief or defense to repayment claim. I know this was discussed in your testimony, but I would like the record to be clear. If you believe General Brown can provide a more technical answer, please feel free to call on him. Many of the questions are simply yes or no. Number one, you have the authority under the law to provide borrowers filing a borrower defense claim full, partial, or no relief. Is that correct?
That is correct, Congressman, and I would love to refer everyone to Exhibit 5 that demonstrates or that shows the portion of the law that clearly states this. I think this has been a question for a lot of people, and I want to make sure it's very clear that it is the Secretary's prerogative to establish full or partial relief.
Thank you. The statute is silent on full or partial relief, but the regulations specifically discuss partial relief. Is that correct?
That is correct.
The Department defended partial relief in both the 2016 rule under President Obama and your 2019 regulations. Is that correct?
That is correct.
The lawsuit in the Manriquez case is about the data used to determine partial relief. Is that correct?
That is correct, not the methodology.
Okay. I know that many of my colleagues believe you should just reward full relief if you find there was harm, but you've decided, as you are authorized to do, to grant partial relief in some circumstances. Is that correct?
That is correct.
Simply following the statute and the rules. Can you please explain why you believe partial relief is important, and what are some examples of where partial relief is appropriate?
Certainly. Well, the previous approach was either all or nothing, and the new methodology that we have developed is a very scientifically defensible approach that looks at standard deviations from median earnings in a program and compares it to median earning. So if a claimant makes a claim against a school with regard to a specific program, we will take the median earnings data from that program, from that school, and compare it to like programs from other schools across the country. And if it's more than 2 standard deviations below that median, the individual would get 100% relief. If it's between the median and 2 standard deviations, it will be a tiered relief. If they're earning more than the median for the rest of the schools, then they would not be entitled to relief. They can't demonstrate that they've been financially harmed.
So that seems very fair to me, to be able to do it that way. If you have a situation where your earnings are what they said they would be, then I agree you shouldn't have relief. I'd like to yield, Mr. Chairman, the rest of my time to the ranking member, Dr. Fox.
Thank you very much, Dr. Rowe. Madam Secretary, the Manriquez case is related to Corinthian borrowers. Is that correct?
Yes, specifically to Corinthian borrowers.
Okay. And the plaintiffs in that suit are seeking relief from their loans because they claim the schools misrepresented their job placement rates. Is that correct?
Yes,
Okay.
they're primarily job placement claims.
Sure. And the plaintiffs specifically challenged your methodology for determining partial relief. Is that correct?
Well, I believe they were taking issue with the entire methodology, and the court held that the data we were using was the issue.
Okay, and then the judge issued an injunction preventing you from using the methodology because it violated privacy protections. Is that correct?
That was that judge's opinion, yes. We
Okay.
disagree with that and have appealed it.
That injunction prevents the department from collecting on the loans of the covered borrowers while the case is pending. Is that correct?
Correct.
Okay. However, there was a problem and those loans were continuing to be collected on. Is that correct?
Well, no, let me put that in context. So a couple things I think are important to know. First of all, before that court case was ever, or that injunction was ever handed down, I had directed that all of the pending student loan or student borrower defense applications be put in forbearance and also not continue to accrue interest. So while this was going on for months and months and months, those students weren't going to be sinking deeper and deeper into their, whatever problem. So that was done before the court injunction. When the judge issued that injunction, that was already the directive. And that directive was the policy or the practice that I expected would be carried forward. After a year, there were some processing errors within federal student aid and with our servicers. So human beings made mistakes. As soon as we became aware of it, we said, we acknowledge it, and we will correct the issues, which we did immediately. And I'd like to ask General Brown to just talk briefly about the numbers and how quickly we have.
Madam Secretary, we'll come back to that when we have a chance. I don't want to go over.
Okay.
Thank you.
The gentleman from Connecticut, Mr. Courtney.
Thank you, Mr. Chairman. Thank you, Madam Secretary, for being here today. Again, I just want to go back to your response to Dr. Rowe about, and again, you were very, I think, specific about the fact that your discretion that's vested in you by the 1993 Student Loan Reform Act allows you to provide both partial and full relief, that you just said that. Is that correct?
Yes,
Yes,
correct.
thank you. Okay, and I appreciate that answer. Mr. Chairman, I just want to now enter into the record a memo dated December 14th, 2017, published in the New York Times from Stephen Menashe, who was a political appointee, acting general counsel at the Department of Education, to James Manning, who at the time had been delegated the authority to perform the duties of undersecretary.
Without objection.
Thank you, Mr. Chairman. In that memo, Madam Secretary, Mr. Menashe, who's now Judge Menashe, wrote that, quote, "It is now OGC's position that the Borrower Defense Unit's analysis, that department regulations and the Borrower Defense Statute allow the Secretary to assess relief at her discretion. Do you believe that this memo, again, provides you the legal basis to provide, in some instances, full relief to defrauded students based on your discretion?"
I'm not referring to the memo, I'm referring to that section of the rule that existed in both the 95 rule and the 2016 rule.
Great, well, thank you, which again, basically says that you have that
There
full
is,
scope.
yes, that the
There's a
secretary
range.
has discretion and.
Right.
And again,
So
because there
again,
was no
we
process
agree,
in
we agree.
place.
I'm not, you know,
Yeah,
thank
there
you
was
for
no
your answer.
process in place, and
Thank you for your answer. I
rather
just
than-
want to just kind of keep going here, because on page 6 of the memo, it goes on to say that, in fact, the only limit to the Secretary's ability to grant relief is that no student may recover in excess of the amount that the borrower has repaid on the loan, which is certainly a common sense statement, and I think we can all agree on that, that you can't overpay with restitution. Is that correct?
Yes.
Thank you.
I mean, I think that would,
So again, since you took office, I know you did process some of the pending claims from the prior administration, but after that cohort, have you provided any defrauded loan borrowers full relief since that first tranche?
well, we couldn't, frankly, because the process was shut down, and
Let me
because we could
talk
not-
about that, because actually, if you look at the court order, which again shut down your partial relief program because of what the judge felt was improper use of Social Security data, the judge actually stated, and I quote, "Nothing in this order prohibits the Secretary from fully discharging the loans of any borrower who successfully completed or who successfully completes an attestation form." So, I mean, she actually still left the door open for the department to continue to process these borrower defense requests.
Yes, but without a methodology that we could access the appropriate data, we couldn't, I couldn't go ahead and say, we can just go ahead and forgive a whole bunch of loans 100%, because number one, each student's application needs to be considered individually. The circumstances are different and the facts are different. And so without a methodology to utilize, we could not continue to process. Now, we
So let me-
continued.
so that what
let
the
me just-
judge-
Let
what
me
the
just
judge-
clarify.
well, okay.
We continued to adjudicate, and we have many claims that are awaiting now being processed to be able to respond specifically to whether there was financial harm or not. And so now that we have another methodology up and running, we're going to be able to, I think, move through those fairly quickly. And
So again,
General
so
Brown-
if I could just follow up with a question again, because my time's about to run out. So what I hear you saying is that these claims after the judge's order stopped being processed because you, through your discretion, determined that they had to come up with another way of processing the claims. But again, that's not because the judge handcuffed you in terms of providing full relief. Her order specifically says that she left that door open for you. It really was your decision, based on whatever, priorities and policies that you had to not continue to process those pending applications. I would just say Congresswoman Hayes and I have about 1,100 borrower defense applications from the state of Connecticut that have been sort of stuck in this queue during that time period, and that's based on June data. I'm sure the numbers have grown. ITT Tech is pretty much the driving institution, which is now defunct. So again, we at least made some progress here in terms of at least verifying what the scope of your authority is, and my time has run out, so thank you, Mr. Chairman.
Thank you. The gentleman from Pennsylvania, Mr. Thompson.
Thank you, Chairman. Thank you, Secretary DeVos, for being here. Much appreciated. I will say, my friend, we worked a lot together on a lot of different issues, but it brought to my attention, I'm appalled that this judge did what they did in what they put forward, basically providing a license to not, just to allow the continued abuse. I appreciate the fact that you came into this particular position, and unfortunately what you inherited from the last administration, which was really no structure, quite frankly, just providing loan forgiveness, which where warranted, where we're harmed, I think that's important, but there is a duty and a responsibility to do this diligently in the right way. And so I appreciate that my colleague bringing that up. It brought that to my attention, how abusive that this judge was with the ruling. Madam Secretary, there are a few myths out there about the 2019 borrower defense regulation that I'd like to discuss with you today. And General Brown might have some of the technical answers to these questions, so please certainly feel free to ask him to answer if you believe that is better. Pretty straightforward. The first myth is that the 2019 rule eliminates $11 billion in relief. Is that true? If not, can you explain it for me?
Well, Congressman, that is indeed a myth. The presumed savings assume and count on the fact that with much more clarity around a school's responsibility and what a student's claim would and could mean, that we will have ultimately fewer borrower defense claims going forward. Let's just recall the fact that from 1995 to 2015, there were a total of 59 claims filed, and then a 5,000% increase from 2015 to where we have almost 300,000 claims today. And so going forward, we've just released a ton of data on the college scorecard that individuals, if an institution is making claims about a program, it's going to be easy to check. You can go to that school and that field of study and see what the earning is for the first year, and we're going to continue to add the data for years after that. So a lot more transparency for students and for schools, frankly. And so going forward, the savings are going to be around the fact that we're not going to have as many claims.
A great tool for financial literacy.
It's a good argument for financial literacy, yes.
Another myth is that the rule eliminates accountability for-profit schools. Is that true?
Not at all. Indeed, it really treats all schools equally, and I think that's one of the major deficiencies of the 2016 rule. It was strictly focused on for-profit institutions. In fact, I saw some internal stuff at the department saying, well, we're not going to pay attention to any claims or any schools that a liberal arts program, because it's presumed that they're of the full value. Well, that's just wrong. I mean, if a student has a claim against a school that for being fraudulent and deceptive, that should apply across the board to every school. We know that UC Berkeley fudged their numbers to get bumped up rankings in U.S. News and World Report's college rankings. Should those be subject to borrower defense claims like the others were?
And yet another myth is that the rule is cumbersome or overly burdensome to comply with from a borrower's perspective. Is that true?
No, in fact, we've made it very easy for students to find the information they need. It's prominently located on Federal Student Aid's website, and we want to make sure that if and where there are these claims that are legitimate, that students have a very clear path to understanding how they proceed.
Thank you. Chairman, I yield what little bit of time I have to the Republican leader, Dr. Fox.
Thank you. And rather than ask a question, I'm going to make a statement. Just tell me if I'm saying this correctly. It was asserted before that the judge gave you discretion to go ahead and discharge these loans. But my understanding from you is, yes, you have processed all the applications, and once you understand you have a way to do this that's not going to be challenged in court, then you will what you say adjudicate, meaning give an answer to the student. Is that correct?
Close. I'd actually love to have Exhibit
Next-
1 put up for
Well,
the
okay.
process, because it shows where things are, and I'd like General Brown to actually speak to.
I'm going to have to cut you off one more time, but I promise you the next time we'll come to General Brown. Thank you,
Okay.
Mr. Chairman.
You're going to get there yet.
Thank you. Gentlelady from Ohio, Ms. Fudge.
Thank you very much, Mr. Chairman, and thank you, Madam Secretary, for being here today. Once again, I find myself agreeing with the ranking member. We could be investigating other things today, but there are so many in this administration, I don't know where I would begin. Maybe I would start with the 3 USDA rules that are getting ready to cut 4 million poor people off of SNAP, 1 million of them children. Or maybe I could talk about the daily travesty on our borders, but that is not what we're here to do today. But it's unfortunate that my colleagues are suffering from amnesia on the other side of the aisle, because I remember well how they treated the last administration. So they can't take this holier-than-thou kind of attitude, let's all be nice and get along. I remember, I was here. And the other thing I just want to bring to our attention is you talked about the 2 letters or less that you're getting every day. We get that every day too, and we have a lot less staff than you do. So I don't feel it's something that is onerous and something that you cannot respond to. Secretary DeVos, is it fair or lawful to defraud students?
No, it's not.
Very good. Should those people that are defrauded be made whole?
They've been financially harmed, indeed, there should be relief for them.
Thank you very much. I yield the balance of my time to my colleague from Connecticut, Ms. Hayes.
Secretary DeVos. Just really quickly, Mr. Chair, I'd like to enter into the record the January 10th, 2017 memo from the Borrowers Defense Unit to then Undersecretary Ted Mitchell,
Without objection?
which this memo was drafted by your office after the previous administration left. And I just want to say something. As I'm sitting here and I'm listening, I remember our last interaction where you, at that point, had also not read the memos that came from your office. And I just find it just a total lack of regard that after the NPR story broke on Friday, and you knew you were coming here for a memo about, for a hearing about Borrowers Defense, that you wouldn't even take the time to acquaint yourself with the memo that was talking about that your staff recommended that borrowers be given full and complete relief. There's nothing, as my colleague, Congresswoman Fudge said, so incredibly onerous about 1.8 letters a day from Congress. You have over 3,000 staff and a budget of $60 billion around plus dollars. I get more than 2 letters a day, and I make it my business to respond to them. So I am going to follow up about this same memo, and I hope that, as you said before, you don't know what anyone's talking about. You haven't read it. You heard of the story, but don't know the memo. But in this memo, your staff recommended that full relief for borrowers who enrolled in ITT colleges and campus in California be granted. Can you explain why you ignored that memo, and then why you did not include it in the documents that were sent to this committee?
Well, Congresswoman, once again, without having the document in front of me, I'm not going to continue to comment.
Did you not know you were coming here today?
Congresswoman, there are hundreds of documents written.
You're absolutely right, and I would accept
and I would
that,
just-
but the
I would just
fact that on
clarify-
Friday, this story broke and this document specifically was referenced, I don't think it's unreasonable. I know I'm a freshman congresswoman. If I were coming to a committee and I had taken the time to prepare, and a document was revealed in an NPR story that went nationwide 5 or 6 days before the hearing, I would say to my staff, can you get this document for me so that I can read it for myself? Because I am sure that this committee will have questions in relation to this memo. That didn't cross your mind at all?
January 10,
No, Friday, last Friday,
10,
last Friday.
January 10, 2017 was the last administration.
Did
I
it
was
not
not
cross
in
your
my
mind?
office until
Did it-
February 7,
Did it not
2017.
cross your mind when the
There
story
are
broke?
hundreds of documents
You're
that
absolutely
pumped
right,
out
but
from-
on Friday,
and
when
it's-
this specific document was revealed, did it not cross your mind that maybe I should read it on Friday?
No, I don't
So,
need to read the
In
document.
December
I
2019,
know
when
what I have.
NPR ran a story, it didn't cross your mind that maybe I should read this document?
I don't need to read every document.
No, this one
originated
specifically, not the thousands of others, just
because-
this one.
Because a news outlet chose to print it?
Yes. Is that a no?
I should read everything that a
Yes or
news
no? Did it not
outlet
cross your
chooses to
mind
print.
that you should read this
I am-
document?
Ma'am, I am focused on getting a
So no?
process right
So no?
for students and for taxpayers.
So no?
On getting a process right for students and taxpayers.
So no?
And that's what I'm doing.
Part of getting that process right requires reading. Thank you, Mr. Chair.
Gentleman's time is expired. Gentleman from Michigan, Mr. Wahlberg.
Thank you, Mr. Chairman, and thank you, Secretary, for being here. General Brown as well. Again, January 10th was before the inauguration, and February 17th was when you were confirmed. And I hope it doesn't concern my constituents too much that I don't read every article that's written about me either. There are certain articles that would be a waste of time and take me away from doing the job that I've been asked to do, especially when you know what you're supposed to do and follow the law. Talk to us, if you will, about your exhibit number 1. Give the opportunity at this time.
So thank you, Congressman. Exhibit number 1 shows the process through which we go with every borrower defense application. And I'd like to ask General Brown to talk just briefly about it so we can understand where we have come, where we have brought the borrower defense claims to prior to having the new methodology to process.
Thank you, Madam Secretary, and thank you, Congressman, for that question. I would just remind the committee that overall, we are fastly approaching what will be almost 300,000 borrower defense applications by the end of this calendar year. And each case is adjudicated on its own merit. And what that means is there is no blanket way to do them all because they vary greatly in how what data is there and also the validity of each case without regard to which school the person the student went to. And we do not look at them per se by school. We adjudicate the individual cases. So the type of school is less of issue than the validity of the case. For every one of those cases, we bring them in that top bar that you see, and we have our administrative people as well as our attorneys take them apart, look for supporting documentation, and check the validity of that documentation. And this is the first part of the case. If it happens to be under the 2016 rule and the case is determined to in fact be a valid case, then the school would be notified under the 2016 rule and those going forward. Not all are under the 2016 rule. At that point, the case would start the adjudication process. All cases get to that point. At that point, that's the borrower's defense regulations that you all have supported. Across administrations, and we looked at this across administrations only because those were the questions that we have gotten, the percent of those that were valid and invalid really has held true. It's been about 62% to about 38% throughout both of those times, and for the first 65,000 of those cases that have been completed, adjudicated, and processed back down to the students. However, at that point, if the case is in fact either ineligible or eligible, if it is eligible, that is the point at which, as the Secretary said earlier, she has the discretion to determine some, or a methodology that will determine some, none, or all. When you talk about a backlog, when you use that term, those cases got to that final point, had to be stopped, as you all have already referenced, by the Ninth Circuit, and so that's the backlog. And it is the decision upon which the Ninth Circuit either answers the appeal or a new methodology has to be determined. And so when you use the term backlog, that is what we are taking each case based on its individual merits through.
Okay. Thank you for that explanation. Previously, there was no official source a student could access to see college outcomes at the programmatic level. You recently unveiled new information on the college scorecard that would allow families for the first time to compare programs within an institution or similar programs at different institutions. Could you please explain what consumer information is included in this tool and how providing this information up front will help students make informed decisions before starting their school?
Sure, Congressman, I'd love to talk about it a little bit more. Previously, you could go to look at a school, cost of attending a school, average cost of attending a school, and then what the average earnings would be expected for a graduate of that school. That's nice information, but it's not particularly useful for students based on programs that they choose. Now, with this new data release and this new approach, you will be able to go look at a school and then go into the field of study within the school and see what your cost is for attending that program, and then what your earnings potential is, what the earnings have been for students who have graduated from that field of study their first year. And we're going to be able to add subsequent years as more data becomes available. But this is going to give students a whole new tool to use in decision-making around what kind of education to pursue post-high school. And it's going to be, it is useful for two-year programs, for certificate programs. We are also linked to apprenticeship opportunities through the Department of Labor. So a very robust set of data and important tools to be used for students as they begin to think about their futures. And I think importantly for institutions to maybe ask some hard questions about some of the programs they've been offering that may not be, the value for cost that they should be.
Glad to hear back. I yield back.
Thank you. Before I recognize the next member, I would like to ask unanimous consent that the document from January 10th from the Borrower Defense Unit has been entered in the record. There's also January 9th and an October 20, January 9th, 2017, and October 24th, 2016. These memos describe an extensive review of claims for Corinthian, ITT Tech, and Everest Wyotech, where students, where the staff recommended full debt relief for borrowers from these schools. These memos, 14 pages and 18 pages, reflect a clear process and evidentiary review conducted by the Obama administration, so that we just want those in the record. Gentlelady from Florida, Ms. Wilson.
Thank you, Mr. Chairman, for holding this hearing. I'm so happy that Secretary DeVal's schedule has finally allowed her to address this pressing issue here today. Madam Secretary, there are 200,000 students that are still waiting to have their borrower defense claims processed by your department. The Education Department has not approved a single new claim for loan relief in the past 18 months. If a student takes out a federal loan to study at an institution that behaved fraudulently or deceptively, that student's loan should be forgiven. Mr. Chairman, tens of thousands of borrowers acted in good faith as they applied to school and took out loans looking to better their lives. Because of bad actors, they were left with unfulfilled promises, outright lies, and mountains of debt. I believe that it is incumbent upon us to provide relief for those harmed by schools that acted in a fraudulent manner. Secretary DeVos, you wrote with extreme displeasure on the document that discharged loans that had already been through the BD process prior to your appointment. Why would you write that? Why would providing relief to defrauded borrowers whose claims have been reviewed by experienced professionals displease you?
Congresswoman, very good question. Very simply, there was no process. The claims were simply forgiven without consideration for the individual circumstances.
Secretary, I heard you say that. I want to tell you a story about a borrower from Florida named Jessica Madison that gives me extreme displeasure. In January 2017, Ms. Madison was told her borrower's defense application had been approved and that her $19,000 in student debt would be forgiven in 60 to 120 days. It was not. And instead, the government began garnishing her paycheck to recoup the money. As a result, she did not have electricity for weeks because her garnished checks couldn't cover the bills. How is it possible that the Department of Education could have continued to collect Ms. Madison loans after she had already been approved for a borrowing defense loan? After the Washington Post wrote about her story in July 2017, the garnishment stopped. They did not refund her money. Just $2,000 was refunded of the $12,000 that had been garnished from her wages. Do you believe it is appropriate to not fully refund wages that were garnished for student loans that were deemed fraudulent?
Congresswoman, when a student's borrower defense claim is deemed to be, they have been financially harmed, and we have a process to consider that, the level of that, the students are made whole, and the students, we address each student's issue and situation individually. That's why it's important to have a process, because every student's situation is unique.
Do they get all of their
unique and
money
different.
back that was taken from them?
It depends on the various claims.
Because of these wage garnishments, Ms. Madison could not afford to see a doctor to address the intense pain she was experiencing. When she finally did go to the hospital, she was diagnosed with cancer. In October of this year, she passed away. Secretary, can you commit to me today that you will personally ensure that Jessica's wife will receive the remaining $10,000 owed to her by the government?
Congresswoman, I can assure you that we can and will look into that specific situation if provided the details. And once again, I go back to the fact that all of these claims, all of these students' claims need to be considered
I have worked in
individually.
education my entire life. I've dedicated my life to this work. I've worked with Democrats and Republicans to advance the goal of quality education for young people. I've had some honest disagreements with my friends in the Republican Party about how to move education forward, but I've never, not one time, believed that they were out to destroy public education until I met you. Why has every decision you've made harmed students instead of empowering them? Are you the Secretary of Education? You are supposed to be their champion. When you approach a public school, you are protested. If you entered, you are booed. When you spoke at an HBCU in Florida, 2 months later, the president was made to resign. You are the most unpopular person in our government. Millions will register to vote in 2020. Many will vote to remove you more than to remove the president. I yield back.
Mr. Chairman, I just have to say, one of those last comments is over the line, absolutely over the line. To say that Secretary DeVos is trying to destroy public education is going too far. And I believe every one of my colleagues agrees. We all set up very quickly when that comment was said. Now, I like Representative Wilson. She and I have talked a lot, and we are very concerned about education. But that kind of comment cannot stand in this committee. The Secretary has come here to help us with our
Point of
job
order,
of
Mr.
oversight.
Chairman. The gentlelady is taking time that was not recorded.
The ranking member is making a point of order.
Mr. Chairman, Mr. Chairman,
Mr. Chairman, I believe if that had been said on the floor of the House, it would have been, those comments would have been taken down. Thank you.
The gentlelady's comments are well taken. Next person to be recognized is the gentleman from Kentucky, Mr. Guthrie.
Mr. Chairman, I have a point of parliamentary inquiry.
I'm sorry, gentleman from South Dakota.
I'm just a freshman, sir, so I don't know the rules backwards and forwards. Is there a mechanism by which a vote of this committee could strike those comments from the record?
Just a minute. The comments from the gentlelady from North Carolina have been part of the record, so I think we have both sides, and I have agreed with the ranking member.
Mr. Chairman, my point of parliamentary inquiry is whether or not there's any...
We should refrain from questioning the motives of the members
Thank you, Mr. Chairman.
and the witnesses. Thank you. Gentleman from Kentucky, Mr. Guthrie.
Thank you, Mr. Chairman. Appreciate the opportunity to be recognized, and sorry that tone in Washington has reached the way it's reached the last year. I apologize for that. Somebody's been here for a while. We hate to see it's deteriorated the way that it has. We need to be working together to get big things done for this country, and unfortunately, we're where we are. But I want to get to my questions. I'm sure you agree that Congress has a responsibility to do oversight of the administration, and I believe you said that 95% of all congressional requests have been met. Said that earlier.
With regard to the letters, and let me just add, the 1.8 letters are not just like constituent, nice, can you respond with a half page or a page response? These are voluminous responses required that require a lot of research to respond to, and often hundreds, if not thousands of pages to be responded in each of them.
I was going to ask, it included phone calls, emails, and written responses. I think you answered that one.
No, these are voluminous responses
And then
in
long
writing.
ones as well. And I'm sure you agree that it's important for all parties involved to communicate directly, is what you said. So I want to get to this hearing. I agree that borrowers that are harmed should be granted relief as quickly as possible. After diving into some of the nuances about this issue, I understand why you have decided to grant partial relief in some cases. Now, it is my understanding that there was a report that estimated the borrower defense claims would be cleared by the spring of 2017. But your decision to review those cases and grant partial relief meant that the estimate proposed in the report would not be met. Is this correct?
Yes, again, Congressman, there was no process, and short of simply deciding to forgive all of and accept all of the claims with 100% validity or not, we needed to get a process in place to consider each claim.
Thank you. So the memo I just mentioned, was that an official memo that included promises or any guarantees to borrowers?
I'm not sure what memo you're
It's the one that said about spring of 2017 you would, but anyway, so it wasn't official. So I'll get to this. So there wasn't anything illegal about your decision, about your determination that it was the best interest of taxpayers to review these claims and make sure the relief granted was correct. So I guess my question is, there was nothing legally requiring you by the spring of 2017 to make those decisions, and you made the decision to put in a process that made sure the fraudulent claims were paid, but need to make sure the claims were fraudulent, and so you made those. There's nothing illegal about where you are today about not getting that done by 2017.
No, it was a matter of building on a lack of policy and process from the previous administration. The policy of the previous administration was to simply forgive claims. However, there was also some opinion expressed that up to 40% of some of the claims that had been submitted did not qualify. So again, without a process and a framework, we couldn't proceed and progress any of those claims forward, which is exactly what we did when coming into office in 2017.
Well, thanks. I appreciate that, and I want to yield to the ranking member, or the Republican leader.
I want to thank the gentleman from Kentucky. I want to point out, I want to make several clarifications. Number one, some of our colleagues don't know, evidently, the calendar in 2017, because the memorandum under consideration here, that has been brought up, was a memorandum to Undersecretary Ted Mitchell, who worked in the Obama administration. The Obama administration was in office until January 20, when the President Trump took office. You, again, pointed out you did not come into office until February. So if they have an argument with anybody, it ought to be an argument with these folks who got the memo on January 10. This sounds like a lot of other memos that came out around that time. I'd also like to point out that contrary to what has been said, that for-profit schools have no value, 1995 was when borrower defense rules went into effect. Corinthian colleges were formed in 1959. ITT was around since 1969. Between the time borrower defense went into effect, as you said, Madam Secretary, until 2015, 59 claims were filed. So obviously, something happened. Yes, those schools closed, but there's been a culture change, I believe, in our country in terms of what people believe they're owed. Thank you, Mr. Chairman. I yield back.
Thank you. Gentlelady's time expired. Gentlelady from Oregon, Ms. Bonamici.
Thank you, Mr. Chairman. Thank you, Secretary DeVos, for being here. And thank you, Mr. Chairman, for introducing into the record the January 9th and January 10th, 2017 memos. Secretary DeVos, when you made opening remarks, you said that some on this committee suggest full relief for defrauded borrowers. The point is that it's not just some on this committee. It was the Borrower Defense Unit in the Education Department as well. People who had been working on these cases. That's the point. And Secretary DeVos, the mission of the Department of Education is to promote student achievement and preparation for global competitiveness by fostering educational excellence and ensuring equal access. And when I look at how the department and you have been handling the borrower defense cases, I just don't see that that is consistent with the message and the mission of the department. With so many hundreds of thousands of students, including thousands in my home state of Oregon, stuck with loan balances and a worthless degree, if they even got a degree. I'm a former consumer protection lawyer for the Federal Trade Commission, and I know fraud when I see it. And these students were misled and cheated, and the fact that some of them may be making money doesn't mean that they weren't defrauded. If somebody went into one of these programs hoping to become a nurse, for example, and now they're selling clothes at a department store, it doesn't mean that they weren't defrauded. And I hope you can put yourself in the shoes of some of these borrowers. I know it's challenging, but they went to try to find a better path for themselves. And instead of getting a good education, they got collection notices and wage garnishments. And in September, the department admitted to violating a court order by illegally demanding loan payment from more than 16,000 Corinthian borrowers seeking borrower defense. And that number has now increased to 45,000. And the issue came to the public's attention only after you were held in contempt for violating a court order. So this is not a new problem. In fact, more than a year ago, a court ordered the department to stop seizing tax returns of borrower defense applicants. That was the Williams case. So you and the department have known about this issue for years. So why did the department continue to bill more than 16,000 Corinthian borrowers in violation of the law?
Well, Congresswoman, I'm sorry you weren't here when I talked about that earlier on, but what I said was it was very clear that the borrowers that made claims for Corinthian college programs were in forbearance, were not accruing interest per my direction prior to the court order a court injunction in May of 2018. Since then, a year later, there were errors made within federal student aid and with some of our servicers, human errors that once we became aware of them, we immediately acknowledged and immediately went to work to correct and rectify the problems for those impacted students.
And I'm going to reclaim my time and ask another question.
It's 99.8%.
I'm going to reclaim my time and ask another question. And I was here, I just didn't find the answer satisfactory. How many times has a court already found that the department has illegally collected payments from borrowers or seized their wages or tax returns?
How many times? It was.
Have other courts found that?
In relationship to the court injunction from May 2018, and General Brown can comment to the specific numbers of impacted borrowers, and frankly, what we have done.
For the record, there were other cases
to make sure that all of those cases were addressed and taken care of, which they have been.
And you say, Secretary DeVos, that you care about the responsible use of taxpayer dollars. So the judge in the Manriquez case imposed sanctions in the amount of $100,000 for violating an injunction. So who paid that? You personally or the taxpayers?
I'm not aware that it's been paid. It's an injunction and a judgment against the Department of Education.
So you're not aware if it's even been paid?
I don't believe, I don't know. I can.
And who do you expect to pay that? Will you pay that personally, or will the taxpayers pay
Well, I
that?
think there is a appeal to suggest that it's not appropriate to fine another federal department.
So, in my remaining time, it was the borrowers who discovered that the department was billing them improperly. This is not a result of the department's oversight. So we know there are many borrower defense claimants who are watching today. How are you going to assure them that you're doing everything in your power to help them get relief, and that they won't have their wages garnished or their tax returns taken in the future?
Well, I'm very hopeful that we will be able to continue to move ahead with our new methodology, and assuming no challenge from through the courts of that methodology, we'll be able to process these claims that have been pending for many years.
And that's the methodology that if
that's
someone's making
that's
money,
a
they weren't
focus-
defrauded. And
that's a
that is
focus
not
on-
justice, Madam Secretary, and I yield back.
Thank you. Before I recognize the next witness, I'd like to enter into the record a OIG report. In response to this report, the present Department of Education, FSA, stated about the previous administration's process for adjudicating claims. They said, and I quote, "Despite these challenges, we are pleased to note that the OIG did not identify any errors in adjudicated claims, and that the review for each of the sample claims was properly documented. In addition, OIG found that FSA created policies and procedures for borrower defense that have evolved over time as FSA has continued to redefine its processes." The OIG report is dated December 8th, 2017, so that's during the present administration. Without objection, so ordered. And the gentleman from Alabama.
Thank you, Mr. Chairman. Secretary DeVos, General, thank you for your service to our country. It's not often said enough that people like you have given a lot to this country and continue to do so. We appreciate you being here today, and we appreciate your service. I'm going to ask some questions about oversight, and I'm going to direct them to the Secretary, but General, if it's something that you need to be the one to answer to, just feel free to jump in. Let's just begin with the basics. Do you believe in the need for congressional oversight?
I do, Congressman.
Well, I think your presence here today proves that, but I wanted you to be on the record to say that you believe in it. Have you informed your staff of the need to be responsive to Congress to help us do our job?
Indeed, I have. I am very keen on making sure we are responsive, and have repeatedly directed all of my team that we must be, and we must do so in timely fashions.
And how do you follow up with them to make sure that they're doing that?
Have a regular reporting relationships depending on the area and the department, and with respect to the issue that we just talked about, I get daily reports on how those claims have been restored back to their standing that they should be in forbearance, and we are continuing to have regular dialogue and updates on those. And General Brown, did you want to?
Yes, sir. I can provide you one example of those daily reports on Exhibit 7. We are asked for all of those students that had some element of error that were involved in the Manriguez case when they were erroneously put out, taken out of forbearance and perhaps billed. Since that time, we have done daily reports on each one of those cases. This is not a report that we created for this committee. In fact, it's 2 days old. It talks about 0.5 or so % of those cases having not been remediated, and today that's actually less than 30 of those cases that have not been remediated. We are responsible for giving that report to the Secretary each day, and even if it's at 99.5%, we won't be through doing that daily report until it's 100%, meaning every particular person, specific person, that had any element of harm done to them has been corrected. So if they had a Treasury offset, like I heard earlier in the statement, that the Treasury would have had to refund that money for us to put them in a remediated status. And that's one way that we provide oversight of this process and then responsiveness to the Secretary's request.
Well, thank you. That was very helpful. Thank you for providing that to us. Now, I know you get multiple requests from the same member or several members of Congress. How do you prioritize requests when you get multiple ones from the same member? And what kind of communication do you have in place to ensure that your staff is still able to meet the standard for response that you set?
Well, our prioritization is really based on responsiveness in general, and we try to be we try to be able to respond within 30 days of receipt of one of those requests. Sometimes it has to go longer than that, depending on the volume of material requested and required. But we are very focused on ensuring that we continue to work through these issues as promptly as we possibly can.
And I think you've already said this, but you remind me, what is your response rate to Congress since you've taken office?
95%.
Pretty good. What some of us would like to have that rate with our constituents, I might say. Is there a different standard for oversight in the Federal Student Aid Office and in other offices at the department?
No, we have high expectations for ourselves across the board.
And General, this may be for you. How does the FSA balance the request for data and information with the need to get your job running the loan program done?
Thank you, Congressman. Our desire is to answer all correspondence within 30 days. However, I will tell you that those that are very data-centric, that require special pulls from what is 11 loan servicers across the country, often will require more time because that data simply doesn't exist in the systems that we are working to reform. But for most data requests, we try to do those within 30 days.
Thank you for that. Thank you for your hard work at trying to be responsive to Congress, and thank you for your professionalism and for understanding that the taxpayers' money is precious and that we have a responsibility, all of us, including those of us in Congress, to safeguard that money. And with that, Mr. Chairman, I yield back.
Thank you, and I will remind the members to please direct the questions to the Secretary. A gentleman from California, Mr. Takano.
Madam Secretary, you've twice testified today that all pending claims in the Manriquez case, you had ordered into forbearance and not to collect interest prior to that court decision of 2018. And you referred to processing errors were made a year later. Are you aware, in fact, that your department submitted in a compliance report to the court on October 8, 2019, that the compliance errors that we're talking about at issue were not the result of willful or intentional conduct on the part of the department, but as the court has recognized gross negligence, including negligent oversight over the department servicers? You're aware that that's your own department's words. Are you aware of that?
Congressman, what I know is that once we became aware...
It's a simple yes or no question. I have many questions.
I know, but it's not a simple yes or no.
No, but I'm just asking if you're aware that that's what is in your own department's submission to the court, that your department conceded that it was gross negligence for this, for the loan process errors.
There were made on both federal student aid's end of things as well as...
Madam Secretary, on November 21st, 2019, your department, by the way, I want to enter this into the record, Mr. Chairman, the statement of the department, the response to the court.
Without objection.
Madam Secretary, on November 21st, your department held its first ever quality assurance and performance meeting with executives from all the loan servicers to review the Manriquez case. Why did you and your department take 18 months for this first meeting to occur with your loan service providers? Why did it take 18 months to do that?
The loan servicers are we're continually in dialogue with the loan servicers.
It took you 18 months to have your first meeting with these executives. Why did it take so long to do that?
Are you interested in learning, or are you
interested? It's a simple question. Why did it take so long for you to meet with these loan servicers?
I am very pleased with the leadership of General Brown, who came to Federal Student Aid 9 months ago, assuming the Chief Operating Officer role. He is responsible for the operations of Federal Student Aid.
Madam Secretary, he came on
as
board
well
much
as
later in the process.
Relationships with the loan servicers.
Moving on, Madam Secretary, on May 25th, 2018, a federal court ordered you to stop collecting on former Corinthian borrowers in the Manriquez case. 17 months later, in October 2019, Federal Judge Sally Kim was highly critical of you and your department's attempts to comply with the preliminary injunction. It consisted of, and she stated it consisted of inadequate communication with each of your 9 loan service providers. Is it correct that your department's only communication with loan servicers, loan service providers during this time was through email?
No, that's incorrect.
Mr. Chairman, I would like to enter into the record the emails cited in Judge Kim's order. One email only was 3 sentences long. The other email to loan service providers didn't even cite the fact that the department was under a court order.
Without objection.
The judge was astounded, Madam Secretary, that your department only sent emails and did not have in-person meetings or phone calls with the loan service providers explaining the court order. Judge Kim asserted that it would have been normal for any entity under such a mandated court order to have in-person meetings with the contractors immediately following the preliminary injunction, not several months later on November 21st, 2019, which is 18 months later. Mr. Chairman, I already asked you consent to enter the emails. Mr. Chairman, I want to point out that on May 29th, the May 29th email was only 3 lines, providing instructions to loan servicers, and on July 5th, the email that they sent to additional 5 servicers contained no mention of the preliminary injunction. Madam Secretary, who at the department did you assign responsibility for ensuring that the loan servicers complied with the preliminary injunction?
Congressman, I am very pleased with General Brown's leadership at Federal Student Aid.
When did Mr. Brown come on board?
Congressman, can I please finish
When did
my
Mr.
sentence?
Board, my question was, when did you assign who did you assign responsibility for compliance?
Federal Student Aid has a chief operating officer responsible for the operations of Federal Student Aid. General Brown is responsible as the chief operating officer.
When did he come on board?
For those operations. He assumed the COO role 9 months ago. He was with the department for 4 months before that.
So
And
he was
prior to
responsible,
that, there were
you immediately
acting
assigned him
individuals.
responsibility to ensure that your department complied with the court order? Who did you put in
Congressman,
charge?
we have continued to be intentional about complying with the court order. We have acknowledged that
Madam Secretary, you got to answer my question. Who did you assign responsibility to comply with the court order for your department?
Chief Operating Officer of Federal Student Aid is responsible for the operations of Federal Student Aid.
You're referring to Mr. Brown, but he didn't come into this role until 9 months ago.
There was an acting Chief Operating Officer.
Who was that?
That pre-existed him. It was James Manning as an acting. And prior to that, there was, when I came into the department, I inherited a chief operating officer who left his role rather than come and testify here before you.
I yield back, Mr. Chairman.
Gentleman's time has expired. The gentleman from Indiana, Mr. Banks.
Thank you, Mr. Chairman. Secretary DeVos, thank you for your service and your leadership. A lot of discussion today has been about what happened in the past on this issue, but I want to take a moment and focus on steps moving forward. General Brown might have more of the detailed answers to my questions, so feel free to have him answer if you prefer. First of all, for the borrowers that are waiting for relief, when can they expect to hear from the department on whether they are eligible for relief? And if a borrower is indeed eligible for relief, approximately how long will it take for an individual to hear how much relief they are going to receive? Will it take years, or are you working to make sure the borrowers are aware as soon as possible?
Congressman, thanks for that question. Now that we have a new operable methodology, we are going to be able to process the pending claims much more quickly, assuming we don't get stopped in some way by a court order. General Brown can comment to the specifics of how quickly those claims can be processed, but I know that he has continued to increase the staff in this area to be able to really address them in a very timely manner, and has hired many additional attorneys to be able to look at each claim individually as it must and should be done. General, would you like to comment to the timing?
Yes, Madam Secretary. I would say that even within the last 24 hours, we are notifying students of their eligibility or ineligibility if they have given if they provided a claim. We continue to do that Those claimants, they would know now, and if they got relief, they would do so within the next, or actually have it done within the next 60 to 90 days. I would also say, though, that the staff at its height was 14 in previous years. We have more than triple that with a special emphasis on hiring attorneys, and frankly, the more of those that you have, the quicker you're able to get to these cases. So minus any litigation, we expect to get to those cases fairly quickly. But another part of this is the system, which we've been rebuilding over the last 12 months, and that systems platform is ready. So to answer your question, Congressman, we expect to clear the majority of this backlog, minus any further litigation, over the next 12 months.
Do you have the staff that you need to do that currently?
So I'm happy to say that both the systems and the authority and resources to hire the personnel has been given to us by the Secretary, and we have either hired them or they are in the process of onboarding them. So again, minus any litigation, we have what we need or will have very shortly.
Are these permanent or temporary staff people?
The majority of them, some of them are what we would call term employees. We did that out of consideration and out of stewardship, frankly, for the fact that we would not expect to forever receive what we are receiving now, which is somewhere in the neighborhood of 1,200 cases per week. So these are temporary 3-year term hires, and we will see at that point if we need to extend them further.
Secretary, who is involved in how a final decision on relief is made? Do all of the borrower defense claims come to General Brown or you for final approval, or are lower-ranking employees empowered to make that final decision?
Well, Congressman, I have approved the policy, the process for which, by which these claims will be determined, and it's General Brown and federal student aid's role to implement that policy and see through the processing of the claims. It's really a mathematical, scientific a formula and approach. So the policy lays out that framework clearly.
Okay, let me change my line of questioning just a little bit. Borrower defense seems like an inefficient way to protect taxpayers from fraud, given that the government is losing money in the end. What reforms are you making to help prevent the need for borrowers to use this provision in the first place?
Congressman, thanks for asking about the college scorecard. We've made considerable changes to and enhancements to the data available to students and frankly, broadly to taxpayers and institutions. So now, prospectively, students can look at the cost of a college program, a field of study, what the cost is going to be, and what their earning potential is the first year after. We'll be adding data and information to that as subsequent years become available. But this is going to help clearly reveal whether the value for a program is there. And frankly, I think it's going to help a lot of schools make some decisions about whether to continue programs that they've been offering as well.
Thanks to both of you for being here, and thanks for always being willing to answer my questions and provide anything that our office needs along the way as well. With that, I yield back.
Thank you. The gentleman from New Jersey, Mr. Norcross.
Thank you, Mr. Chairman, and Madam Secretary, thank you for being here today. I want to start out by saying I agree with my colleague on the other side that we wish that we would work together much more often. So let's see if we can start with you and I, that we get direct responses to direct questions and be respectful of each other, which is something that I'm sure you want to do. Let me start out by asking you about the partial relief formula that uses the college scorecard data. Talk to me about that, how after 18 months, I guess, since the quarter you rolled this out, why you thought this was the best scorecard, particularly when you only have 20% of the programs involved in that now. How did that become the best one?
Well, Congressman, just to be clear, we're using several different data sets to,
But aren't you using the scorecard?
as one of the data
Great.
sets, yes.
And do you agree that it only has 20% of the programs?
Yes, well.
Okay, so please continue.
So we are using several different data sets, and in looking at each borrower defense application, the field or the program of study that the applicant is claiming was fraudulent in some way, the median income for that program is compared against the median income for programs like programs
You understand, but
from other institutions.
So what are you were going to tell us? What else you were using?
The other pieces that we're using are Social Security Administration data and the 2017 gainful employment earnings data, and IRS
But they don't
information.
reflect back to the individual programs that people are looking for. So if my son goes to look at it and says, gee, let me go to the scorecard, that's the only piece of information that program would reflect what the reality is.
The
even though
college
it's 20%.
scorecard, actually, the programs that are include about 80%, I believe, 80 to 85% of the students pursuing fields of study. The smaller programs that are not included in college scorecard are simply because the cohorts are too small to be able to consider.
Well, actually, it makes up 80% of the entire programs. It's the exact opposite. And it only has 2 years. So if it took you 18 months to come up with this new one, it just seems to me to use something that is such a small part of the solution of what's actually going on. Because you agree with me, you're trying to get students, potential students, that information, right? So that they can make an informed
We're
decision.
trying to consider each student's claim individually and the
No,
circumstances.
this is being used, the scorecard, to give potential students an idea of the cost involved and the outcomes. We understand that. But using only 20%, and General, thank you for your service, but I guarantee you wouldn't want to send somebody into a war zone with only 20% of the information. The point I'm trying to make here is...
It's 20% of the programs, but it represents 80% of the students attending higher ed institutions.
But 80%
So,
are the
I mean,
smaller
it's a pretty
programs.
significant number.
Can we agree that the program information is less than you would desire and I would desire?
We'd love to include additional
Okay,
programs,
so
but
that's
we
the
need
point
to
I'm
have
trying to
larger
make.
cohorts.
Because when we looked at this, and again, let's be respectful of each other's time here, 10% relief for the Corinthian borrowers. You made the decision to give them 10%, whether your new formula was involved or not. I have a disabled vet in my district, ITT Tech, which is one of the horror stories. He went there for a digital design degree. School told me he could use his GI Bill. Long story short, he used those stipends to pay for this. And then he found out ITT lied to him, and he is into a $50,000 student loan. Now he's got no job, no degree. I know that tugs at your heart as it does mine. You know, why is it the Corinthians will get a 10% flat over there, but this young man who defended our country gets nothing until you get to his application? How did you decide they're worthy, but this veteran wouldn't be because he was in a different program?
Sir, I believe the Corinthian students have had their institution attacked mercilessly in the media for years, and so in consideration of that and the consideration of the length of time that has lapsed since we were first able to process a number of those claims before the court shut us down, the determination was made that all of them would receive at least some level of
So
relief.
because of media
depending on-
reports, you're going to give them 10%, but this veteran, listen, my time has expired. On behalf of all those students, which I know we all care about, this is impacting their life. I can't suggest to you how important this is to exploit this in a fair and balanced way, and I yield back.
Gentleman's time has expired. Gentleman from South Dakota, Mr. Johnson.
Thank you, Mr. Chairman. Thank you, Madam Secretary. I've found myself most interested on the conversations we've been having about the new methodology, so I just want to learn a little bit more about that. You've talked a number of times about using the median rather than I think the median salary for individuals in these groups. Why does the median make more sense than the mean?
I am not a mathematician, but the median methodology and the standard deviation methodology is a scientifically proven approach to be able to consider these individually and yet fairly. And so the goal was to have an approach that would not only allow for full relief if the student is significantly financially impacted, but also partial relief if there is some financial impact, but not as significant perhaps as others.
So when I mean, a lot of this the heart of this methodology really comes down to comparison to peer groups and peer academic programs. How do you decide what that cohort of comparison programs looks like?
Well, there's similar programs with codes that are considered for each of those programs, and they line up across the board. The previous questioner's line around the percentage of programs included in the college scorecard, it captures, the data captures the bulk of the students and the programs that students have and are attending, and so there are always comparisons to be able to use when using the new methodology.
So we've had some discussion today about to what extent the new methodology is fair or unfair to people who have gone on to better themselves, maybe through extraordinary efforts on their own. Talk to us a little bit about the methodology and whether or not you think it fairly has an impact on students given their different economic salary outcomes in the years after their education.
Well, it actually looks at program to program versus their specific salary. So if an individual has done very well themselves financially, but they have a claim against a school and that particular program, that's the comparison that is made.
So that's an important distinction. I mean, if somebody, they get credit or dispensation for the average impact, negative impact of their program, in that way, their extraordinary efforts, that would accrue benefit to them. They wouldn't be punished for that. Am I saying that right?
Correct.
Okay. And then I want to talk a little bit about the timeline for applying for relief. I think if memory serves, your new rules allow for a 3-year filing timeline. Number one, is my memory right? Number two, why is that the right time frame?
We decided on a 3-year time frame because following a completion of study in a program, 3 years after seems to be a reasonable amount of time, particularly considering the fact that, generally speaking, if there was a claim to be made, that presumably would have occurred at the beginning of the decision to take that program. So the length of time that a student has is really, I think, pretty substantial. Because it could be up to 7 years, frankly.
Do we have a sense, you talked about how, and I don't want to put words in your mouth, so push back if I'm categorizing your statement wrong, but I think y'all had a methodology you were pretty happy with. The courts have told you can't use that particular data set. When you spoke about that earlier, it didn't seem as though you had any idea of a timing on a final decision. Is that right?
That's correct. We have appealed that decision. We believe the data set was a viable use, and the court has not yet opined for over a year.
So have all legal filings been made before the appellate court? Are all the parties, all their stuff is in, we're just waiting on a decision?
We're waiting on the court's decision, yes.
Okay, very good. Thank you, Mr. Chairman. I yield back.
Thank you. The gentleman from New York, Mr. Morelli.
Thank you so much, Mr. Chairman, for hosting this hearing, and thank you, Madam Secretary, for being here this morning to answer our questions. I do find interesting the conversation about taxpayers' rights and interests versus students who have made claims, and I suppose one way to save taxpayer dollars would be to deny all the claims, and I'm not suggesting you say that, but I just find it interesting. What we need to do is find balance, because if we simply just denied all the claims, that would neither be legally or, in my view, morally defensible, but it would certainly save taxpayer dollars. So we obviously want to strike the right balance here. I want to just touch on a few things that I find interesting about the department rules. One of them relates to what they call frivolous factors, and I want to read under the new rule, the department states institutions that include the nicest dorm on campus as part of the college tour cannot guarantee that every student will have the opportunity to live in that dorm. How many students have submitted a borrower's defense claim that they didn't like their dorm room? Do you either know the number or percentage?
I don't have the number for that, but I do have a case file of one that submitted a claim who is trying to claim borrower defense for the fact that he or she did not like their professor.
Okay, but as it relates to, in the rule, it actually cites the nicest dorm rule, and I'm just curious whether or not you could follow up to determine, since it's in the rule, I assume that there were concerns that claims had been made by students that they didn't get the nice dorm room that they saw on the tour.
There have been a number of different, quite unbelievable claims made.
Can you give me a sense of how many frivolous claims, in your view, the 2016 regulations allowed to be forced the department to discharge?
I don't have a specific number to cite because not all of those claims have been not only adjudicated but processed. But I do know that there have been a number of claims made that, you know, your jaw would drop if you actually read the reason for their claiming fraudulent activity.
I'm not sure my jaw would drop, but perhaps other people's would. But one of the things that I was struck by in reading through this, and I'm relatively new to this, my background is in the New York State Legislature, and we obviously are heavily involved in higher education, but not federal programs. But the new rule states that it made the changes to the application process, so quote, borrowers shop wisely, take personal responsibility for seeking the best information available and make informed choices, and accept the benefits of student loans with the full understanding that they generally are legally obligated to repay these loans in full. I was struck by some of the conversation because the institutions that qualify for this and the guaranteed loan program, the requirement is that they be accredited, either by a national or regional accreditation organization. And given the nature of some of the students, particularly that attended Corinthian and other schools that have had claims of significant fraud, it seems hard to me as just an average citizen that you would put the burden on an individual who's looking to go to school, and these are, in often cases, non-traditional students, so they have, they're at work, they may have families, they're challenged, but they want to pursue new careers. It would seem to me that the fact that they're accredited should mean something, and the sort of suggestion that I get is that the expectation is that they would not only take the accreditation, but be obligated to do additional research on the claims made by the college when they go. So if the college says, or a representative says, 100% of our students find jobs after taking this course in the field in which they study, it's accredited by the federal government, has the federal guaranteed loan program, and they're accredited by a national or regional organization. Why should that student be obligated to do further research? Why shouldn't they essentially take that as a proxy, the accreditation that is required by the federal government?
Why shouldn't they take that?
No.
I'm not sure I'm clear.
So
on
the
your
suggestion is, as I understand it, the suggestion is that there is a responsibility on the prospective student to do more research on the credibility of claims being made by people representing various colleges. I would just assume if they've been accredited either regionally or nationally, and there's a guaranteed loan program, that is an indication that the federal government has essentially put the good housekeeping seal of approval. Why would the department, as it seems to suggest in the regulations, require a student to do additional research on the validity of the claims being made by an accredited college?
Well, I think it's imperative that we provide as much information for all parties, and clearly accreditors have a role, institutions themselves have a role, and the federal government as a lender has a role to play. That's why we've continued to improve the information available and to insist on a approach with the regulation that is balanced and that treats all institutions equally.
Well, and I apologize, I'm out of my time, so I'm going to yield back, but I would just say that accreditation should seem to me to shift the balance and the requirement for the student so that they should be able to rely on that, and I don't think that that's what the rule says.
Thank you. Dr. Murphy, North Carolina.
Thank you, Mr. Chairman. Thank you, Secretary DeVos, for coming today. I just want to say I appreciate the effort that your department is doing to try to be good stewards of the taxpayer money. And I think this entire issue highlights some of the problems that the federal government actually has in education. That's a different diatribe. I'll go on a little bit later. But I appreciate you trying to be a good steward, because we are striking a balance between individuals that want to better themselves, to pursue higher education, and also to be one that just doesn't dole out money just because someone claims that they deserve money. I can understand some of the comments, or I would probably shake my head at some of the comments and the reasons that some people claim that they should be reimbursed or whatever. Let me ask you a couple questions, because accreditation to me, just in the medical sphere, seems to be, in my opinion, a way to get a lot of money for institutions that accredit other institutions. And so by definition, in my opinion, accreditation really means about as much as it's worth. You can be accredited by different bodies, and so I don't give a stamp necessarily to some institution that's been accredited. And there is a phrase, caveat emptor, let the buyer beware. So we do take risks whenever we venture into something. But on the other hand, what strategies, what practices does the department use to conduct oversight for these higher education institutions to make sure they are not fraudulent institutions?
Well, the department has a lot of responsibility to ensure that all institutions are treated equally and fairly, and this rule, and I want to get us back to the reason that we're here today to talk about borrower defense and our approach to handling these claims and ensuring that students are treated fairly and taxpayers are treated fairly in the process. We are committed to following all of the rules and the regulations that Congress has provided, the laws that Congress has provided for us, and continue to do so regularly.
Thank you. What form of penalization, if you were, is used by the department for institutions that are having practices that are causing students to have to lose money to, in other words, what type of deceptive practices are penalized, and how are they penalized by the department, by some of these institutions?
Well, the department has primarily fiduciary tools and responsibility. It's a balance between accreditors and states and the department to ensure that institutions are holding up their end of the bargain. And the fiduciary role is primarily through the Department of Education.
Okay, just one final question. Of the students who have submitted claims, what percentage would you say are folks that are doing this as a second, while they're also working at a second job or working a job and doing, versus people who are primarily just using this as their main focus as far as higher education, versus doing it as a second, trying to get a second career?
Yeah, that's a good question. I'm afraid I don't have the granular data on that. I don't know, General Brown, if you have a breakdown on.
No, ma'am. No, sir. We don't collect the data at that level to see if they're doing additional jobs or those kinds of things. We simply adjudicate each case based on its own merit. What is presented.
And just to follow up with that, I feel for individuals who are working and then trying to better themselves. By all means, education is the key to a lifelong career and prosperity. I do think the federal government has led to some of the problems that we're having in higher education now, because the money is so free. It comes without many strings, and if you want to get money and go on, you do. And instead, I think it's led to a lot of bloat within higher education, and we have a lot of kids going to higher institutions that really should be going to community colleges first. And so, to be honest with you, we are part to blame for all this nonsense. So anyway, I thank you for your work, and I thank you for trying to keep us informed and doing the right thing.
Thanks, Congressman.
I yield back my time.
Thank you. The gentlelady from Pennsylvania, Ms. Wild.
Thank you, Mr. Chairman. I'd like to first address the new partial relief formula released by the department. An expert in the field, Dr. Douglas Weber, who is an associate professor of economics at Temple University and was a bipartisan witness before this committee, recently said that the new borrower defense scheme is nonsensical and harmful to students. In particular, he pointed out that the standard deviation, the main tool used by the Education Department, is defined based on the mean and has no direct relationship to the median. In short, his analysis finds that the Education Department has proposed a formula which misunderstands and misapplies fairly basic statistical techniques in a way that makes it materially harder for defrauded students to find relief. I would like to enter his analysis into the record.
Without objection.
Thank you. Moving on, Secretary DeVos, over the past year, the number of pending borrower defense claims has ballooned to 227,000. Many of these are part of group claims submitted by 20 separate state attorneys general, including the one in my state, Pennsylvania. And some borrowers have been waiting for more than 4 years for relief. These group claims represent thousands of students who were defrauded by predatory colleges. There's no question that these colleges engaged in fraud. 24 members of this committee on both sides of the aisle represent students in those states. Now, initially, when those claims were brought, your department attempted to have them summarily dismissed by arguing that a state attorney general could not assert a borrower defense on behalf of a group of borrowers. Is that still your assertion?
Congresswoman, thanks for those, that question. Let me just correct you.
Well, let me just have an answer first. Is that
Let me just
still
correct you. We now have almost 300,000 claims filed.
Okay. All right, thank you.
And
is it still your assertion that a state attorney general cannot assert a borrower defense on behalf of a group of borrowers?
it is the assertion that it's the Federal Department of Education that has, through federal student aid, the oversight responsibility. And the claims continue to be filed by individuals and are considered as individuals.
So I take it then that your answer to my question is yes, that you still maintain that a state attorney general cannot assert a borrower defense on behalf of a group of borrowers.
I know that there
Yes
are
or
many,
no?
I know there are many attorneys general who are marketing the opportunity to file claims. We've seen Facebook ads and many other sources of.
Madam Secretary, I'm sorry, but you seem to be incapable of answering yes or no. So let me just remind you that in October of 2018, a federal court ruled in Williams versus DeVos that the department's actions were unlawful and ruled that the Education Department must review applications submitted by state's attorney general and cease involuntary collection activities against those borrowers. So why are those claims still sitting at the department?
The claims cannot be processed without a methodology to do so. We now have one, and they are being processed again.
And how many of those claims have been processed that were brought by the collective claims that were brought by the state's attorney general since that court ruling?
General Brown will have to answer the question about the specific claims
Why don't
that
you,
have
I'm going to
currently
ask
been-
you to
that
get
have
that
currently been
information.
processed because we just started processing within the last week. So
Okay.
General Brown, if you would like.
Well, no, I don't, the question is directed to you. If you'd like to turn to General Brown and ask him
I've
for
just
that
done that.
information, that's fine, but I want the answer to come from you, please.
So, Madam Congresswoman?
General Brown, would you inform the Secretary, please, of your answer? How many of those claims?
We don't process by attorneys general claims.
Notwithstanding the
We
fact
are
that the federal
processing-
court directed you to do so?
We are processing the pending claims that we have had, and we will take them as the federal student aid department decides they need to be, the ones that they are able to process and are processing first.
All right, I'm going to reclaim my time. In June of 2019, 22 senators wrote to you asking for an update on the status of each of the group discharge applications submitted by the state attorneys general, and your department responded stating that the requests for group relief are in various stages of review by the department, correct?
They are indeed.
And what stages of review is
All
that?
of the claims are going to be considered individually.
On your timetable? Did you not state at the very beginning of your testimony that students are your #1 priority? Because listening today, I have a hard time believing that a defrauded borrower would think that you are in their corner. With that, I yield back.
I was very clear from the start that while this process
yield back.
was being set into place, that no student would assume more interest on their student loan debt, and that they would be held in forbearance. I don't like the fact that they've been sitting there as long as they have, any more than you do. I said that at the beginning, I'll say it again now. Our goal is to get these claims processed and to take each student's claim individually, acknowledging that each student has unique and separate circumstances.
I'm sorry, but
committed to
Secretary
doing that.
DeVos,
I'm
you
committed
have
to
doing
doing
The
that.
gentlelady's time has expired.
Thank you, Mr. Chairman.
Thank you. A gentleman from Kansas, Mr. Watkins.
Thank you, Mr. Chairman, and thank you, Madam Secretary. It's good to see you again, and I noticed also that you tweeted that students are my #1 priority. It's why I come to work every day. I know that to be the case, as with other educators, one being my mother, who's here, was an educator in Kansas for many years, and reminded me of what she'd say when she came home, and students are her #1 priority, and that's why she went to work every day. That's why you go to work every day, and I thank you for that. Obviously, you're trying to work and do the best you can at an intersection between politics and education where everybody's very emotional about the way ahead. And so thanks for your best efforts. You're a patriot and certainly doing the best under this situation. Now, during your tenure, well, before your tenure, a lot of things happened. So I'm going to just ask a bit about the timeline. Let's see, and you can feel free to have a General Brown answer if you'd like. November 2016, the department published new borrows defense regulations. Now, that was the first in some 11 years, I believe. In accordance with the Higher Education Act, the final regulations were published in November 2016, were scheduled to go into effect July 1st, 2017. But you put a hold on them. Why was that?
Congressman, thanks for the question. We were hopeful to be able to delay the implementation of the 2016 rule in order to further refine the rule, which we have now done with the rule that will go into effect next July. As it stands now, we have 3 different sort of buckets of claims and rules under which we will ultimately have to operate: the 95 rule, the 2016 rule, and then prospectively the 2020 rule.
Can you tell us when that process began and how long it took to issue the final rule? And during that time, did you consider and incorporate feedback from higher education stakeholders, including the public?
Oh, yes. We went through the rulemaking process and received input and feedback during the public comment period and responded to that appropriately. Yes.
Well, thank you. And again, I just wanted to say thank you for your hard work, and thank you for all that you do. And I'd like it to be a reminder that the challenge here is to assure that we provide and empower in the case of primary education, the decision-making power to teachers and to parents, and assure that we understand what our limited role as oversight ought to be, because I believe it's best done by the parents and the teachers. And so, thank you again for being here, Madam Secretary, and I yield the remainder of my time to the ranking member.
Thanks, Congressman.
I thank the gentleman. Madam Secretary, if you could enlighten us a little further on how FSA communicates in a constant way with loan services and how they communicate the changes in borrower status when the court intervenes or the borrower files a claim.
Well, Congressman, the communication with the servicers is an ongoing and regular effort, and it continues to be a challenge, frankly. I'd love to have one of the exhibits that we have along here put up, Exhibit 2, to better understand the complexity. When federal student aid was created, I don't think Congress ever envisioned the kind of complex organization that it would be today. And I think you will see with this chart how many different elements there are. The loan servicers all operate on different platforms, so there's not a efficient and effective way to communicate. It makes communication challenging, but one for which we have continued to take responsibility. That is why we have continued to move to the modernization of federal student aid's platform and framework, what we call Next Gen. And we are going to be able to have a better and smoother process and communications flow when we are ultimately able to migrate completely to that Next Gen framework. And if you're interested in hearing more about it, I know General Brown has a lot more detail about that process.
Well, with 8 seconds, 7, I don't think we have that detail, but we'll look forward to it. And but I'm delighted to hear that while it's cumbersome right now, we're moving Next Gen to do it better and complete those 300 and some thousand. Thank you. I yield back.
Thank you. Gentleman yields back. The gentlelady from Washington, Dr. Schreier.
Thank you, Mr. Chairman, and thank you, Madam Secretary, for joining us today. I come from Washington State, and nearly 6,500 students there are stuck. They took out student loans and enrolled in bad actor, for-profit colleges that intentionally deceived them. Colleges closed, credits were worthless, they got stuck with thousands of dollars of debt and nothing to show for it. No degree, no credits that could transfer. One of my constituents from Puyallup, Washington, is a single mother. She found herself broke because she wasn't able to get her degree. Her so-called education prepared her for nothing. She earned very little, was stuck still paying back these loans, even though they gave her no education, and she could not afford to even leave her parents' home. She said, quote, "My son has asthma and sometimes needs hospital visits. When he gets really sick, I can't even take him anywhere. It makes my life a living hell." She has had to take out loans because she has continued to have to pay on this debt. Now, there was a consensus in your own department that all of these Corinthian and ITT loans should be forgiven, that uniformly students got no benefit. And under the Obama administration, a policy was enacted to forgive that debt because they were victims of fraud. But you have continued to collect on those loans. And so students sued, and a judge held you in contempt for continuing to take their payments. And to this day, the Department of Education is still making students pay off federal loans for this fraudulent education, sometimes even garnishing wages. And so my question for you, who considers students their #1 priority, is do you really believe you've done everything you possibly can to help these students and make them whole?
Well, Congresswoman, let me first disagree with the narrative that you just advanced. I have continued to respect the fact that many students' borrower defense applications have been pending, and I have directed that all students whose applications are pending are in forbearance and are not having interest accrue. So the narrative that you have advanced is not accurate. And
So
I am committed to continuing to implement this methodology to now process the pending applications. And I'm very hopeful that we're going to be able to continue to do it without litigation, and that ultimately these borrowers will have their questions answered.
Now, here's my concern, is that you say they're in forbearance, but people are still paying on these loans. They are still racking up.
In the case that they were, they have been remediated, and where we have become aware that they have been inaccurately taken out, we have remediated them, and we'll continue to be vigilant about that.
I'd like to know about what kind of time frame we're looking at, because you have mentored children, precisely the kinds of kids who grow up and go to institutions like this. And I wonder if you could just put yourself in their shoes and feel what it would feel like to go to one of these institutions, be defrauded, be deceived, told that they were going to have a degree, that credits would transfer, that they would have an income afterwards, and then not, and then have to wait this long for forgiveness. Being in forbearance is one thing, but you are continuing to collect on these students. And my understanding is that only about 1,500 cases have been truly processed through to date. So your new process, looking at one case at a time, anticipating another year of waiting, that seems like too long to me. Can you tell me when you anticipate that they will have relief?
I can indeed feel for the students that are going to any institution and having hopes that far exceed what they realize and what they ultimately experience. And we are committed to ensuring that every student that submits a borrower defense claim is considered on its individual merits, and that we have a fair and robust way of considering each of those claims. We are moving as expeditiously as possible to address those claims now that we have a new methodology underway.
So the new methodology has multiple flaws, but there's also nothing that prevented you from simply stopping collecting payments while it was going through this process. But the students are still paying, and some of them going into debt, some of their credit ratings damaged. And I would just like to know what you're going to do to fix this, to get the money back to them, to repair their credit ratings, because there is a long chain of suffering that happens when you're forced to continue to pay on fraudulent debt.
Again, any student that ultimately has a claim that has merit and that for which they have experienced financial harm, we are committed to ensuring that they are made whole in that
Corinthian
process.
students and ITT students, 100% have valid claims because they got zero benefit.
That's simply not true. There are many Corinthian students and ITT students who have done very well.
Your own staff determined it was true. Thank you.
Time has expired. The gentleman from North Carolina, Mr. Walker.
Thank you, Mr. Chairman. Been watching some of the hearing over my office and having some other meetings. I thought all the painful stuff was happening in another committee, but obviously we're making some space on this one, even though we're not the featured primetime spot. Doesn't mean that you can't still say some crazy things in this committee as well. I've got a couple questions, but I'm just kind of pausing to commend you on your strength. Listen, the reality is all of us, when we transition into the political environment, my background is a pastor, some educators, you're not going to get everything right at first, but we are taught to look at the heart. And I think with your career, before coming to this wonderful position, Secretary of Education, of Education that you have, and other things that you've done, I think the heart is pretty clear here on what you've tried to do. It's a little embarrassing to see when it goes personal like it has, but I don't know how you've continued just to kind of take it for 3 years and just keep moving forward, but you have, and I think that shows great resolve. I think sometimes when people have disagreements, it's a shame that we make it personal, because I will tell you, I think only God sees the heart, and I just commend you for trying to do the right thing, I guess I'll ask a few questions if that's okay at this point, so after my commentary is completed. You have released a new methodology for determining relief for borrowers. Can you please walk me through the methodology and explain why you think this is fair and appropriate measure? If General Brown needs to provide some of the specific information, have you to do that as well, so I'll toss it to you. So.
Well, thanks, Congressman, and thanks for the encouragement. The top line is the new methodology really treats students individually and fairly, and also respects the taxpayer. It has established a process, a scientifically proven, demonstrable process to consider students that have made claims against their whatever institution by the program they attended, and it compares the earnings, the median earnings from that program at that institution with median earnings from like programs from other institutions.
All right. I'm sorry, go ahead.
If it falls outside of 2 standard deviations from that mean or median, the borrower would receive 100% relief. And between the median and 2 standard deviations, it would be a tiered approach. And so we believe this is a very fair and good way of
So let me get,
demonstrating that.
so which of these loans does this methodology apply to?
Well, all of the
All of the-
pending, all of the pending claims, with the exception of the Corinthian College students that have been carved out by the previous lawsuit.
Yes.
And we're hopeful that the judge will review this process and permit it for the claims that were pending there as well.
My understanding is that the system used to process these claims and match borrower information is significantly out of date and lacks the capacity to efficiently process the exponential growth in claims since 2015. At least that's our understanding. Could you or General Brown, if this requires a more technical answer, please elaborate as to why this back-end system is deficient in handling these claims and how this can be contributed to the backlog of claims processed?
Well, first of all, Federal Student Aid as an organization in general is a very complex organization. Congress
is.
never envisioned, I don't think, when it was founded, what it would become today. And we're in the process of updating that foundation and framework so that it does more smoothly and easily talk within itself and with its servicers. But I think the ponderousness around this whole thing all speaks to the complexity of federal student aid and the federalization of student lending.
Mm-hmm.
And it has continued to manifest itself. 1995 to 2015, only 59 borrower defense claims in that 20-year period. Since then, nearly 300,000.
Wow.
And it was frankly an all-out attack in the last administration on specific institutions. And I think that's very unfortunate. Our rule going forward will treat all institutions equally. The last administration said they weren't going to look at materials or realities from, liberal arts programs because the value was assumed there.
Mm-hmm.
Well, that's just not a reasonable approach going forward.
And I wanted to hear more from General Brown, but my time has expired, so I'll yield back to the chairman.
Gentlelady from Illinois, Ms. Underwood.
Thank you, Mr. Chairman. Secretary DeVos, do you know how many Corinthian students had negative information wrongly added to their credit reports?
How many students with the mistake that was made most recently?
How many students had negative information wrongly added to their credit report? I'm not asking about your staff, ma'am. I'm asking about you. Do you know the exact number? Ma'am, Secretary DeVos, do you know the exact number?
Congresswoman, I am consulting with the Chief Operating Officer of Federal Student Aid, who is charged with the running and implementation of this program.
Right, I appreciate that. But if you didn't know, the answer could just be no, and that's okay.
I'm trying to find out if I can give you an accurate answer.
Okay.
The reality is, we don't distinguish within the loans that have been pending and processed. So the answer is we don't, that information is not collected.
Okay. Well, so far, your department has publicly released the number, and it's 5,900 Corinthian students whose credit reports were wrongly affected. Now, you're aware that negative information on your credit report, like information that says you're not paying your student loans, can lower your credit score. Is that correct?
All of the students who were impacted by the mistake that was made have been remediated.
We're going to get to the remediation. I was just asking.
I'm going to get to the remediation now
But ma'am,
because
it's
it's
my
been
time.
done.
Reclaiming my
So
time.
let's go on
Mr.
to the
Chairman,
next question,
reclaiming my time.
please.
Secretary DeVos, have you ever been denied a home or a car loan because your credit score was too low?
I have not.
Okay, but you do know how an unfairly low credit score or bad credit report can affect students. What are some specific examples of those harms?
In fact, all of the students that had credit reports affected have been remediated.
Thank you so much, ma'am.
We will
So,
continue to pay attention
you know what,
to
ma'am?
not
Thank you.
having it happen again.
Thank you. So we know that students whose credit reports get harmed, it impacts their ability to buy home and auto loans. It can lead to job loss. The consequences are real and they're personal and they have really devastating impacts on students. So I want to share a few of their stories. Naquisha Johnson from my home state of Illinois earned a degree as a medical administrative assistant from a Corinthian school, but we now know that that degree is almost worthless. But Ms. Johnson is left with those student loans. She just had a job offer rescinded because her credit score shows delinquent loans. Julie Decker from Indiana lost her home and her car while waiting for the debt relief that she's legally entitled to. Now her credit has suffered so much that she can't find a new apartment to rent. So let's go back to that 5,900 number. You previously said that only 900 students' credit scores were affected, but last week you disclosed an additional 5,000 students. Are there more disclosures to come, or can you commit right now that you have discovered and corrected every unfair report on the Corinthian students' credit?
Congresswoman, I too feel for the individuals that you've cited in your examples. And again, once again, am committed to ensuring that we do what's right for all students who have submitted borrower defense claims. We have continued to be diligent, correcting the errors that were made. We have acknowledged them. We have said we are sorry for them, and we're going to continue to be vigilant to make sure that we do not incur more of them. We have put notices in the servicer's files, which has significant implications for future federal contracts.
Sure.
We have continued to make sure that consequences for the mistakes that were made are levied, and that students are we continue to put students first in this case. The ones that did have credit ratings impacted, again, we have addressed those. We will continue, if there are instances in the future, we will do so with them as well.
Right. My concern, ma'am, is that this group of students may just be the tip of the iceberg. Your department just disclosed this larger number, the additional 5,000 students last week, as a result of one lawsuit, as a result of a court order. It doesn't include the Corinthian students who aren't involved in this particular class action, or who joined a different lawsuit with their state attorney general or otherwise. It doesn't include the hundreds of thousands of students who went to fraudulent schools that aren't Corinthian schools, who may also be eligible for borrower defense. And even worse, your own former deputy, Wayne Johnson, gave an interview a few weeks ago about student loans where he said, quote, "Right now, I know that millions of people have unfair information in their credit files that's causing them to pay more on car loans and on apartments." So Secretary DeVos, you both have the responsibility and the existing authorities to do something about it. And what we're trying to determine is what's the right number. Is it 900? Is it 5,000? Or are we into the millions, ma'am? I yield back.
Ladies, time has expired. Gentleman from Georgia, Mr. Allen. Excuse me. The gentleman from Pennsylvania, Mr. Keller.
Thank you, Mr. Chairman, and Secretary DeVos, General Brown, thank you for being here today. Thank you for your service to America's students and education. Appreciate it very much. I have a couple things that I'd like to get into after I just make a couple observations. Secretary DeVos, I know that we all agree, all students who are defrauded by their schools should receive relief. I also want to focus on fairness. Since joining the committee, we have marked up a one-sided Peter Robbs Paul Higher Education Reauthorization Act. The Democrat bill struck me as being incredibly unfair to the students we are trying to help and insulting to the intelligence of the students who made the educational decision in their best interest. As Democrats continue to push policies that double down on failed policies and cuts out specific educational providers, they are not only that are only harming our students. We do a disservice to the students when they focus in on a school's tax returns rather than the educational experience delivered. We can discuss how there are bad actors across the board, but what we should focus on is how we allow students to find the school or educational program that best fits their needs and helps them achieve their goals. And I heard a lot earlier today about not having a process and many things in place for you to be able to do that from the previous administration. So I just have a couple questions. Can you tell us about what the department is doing to help students and prospective students better understand the options available, Like, does the college scorecard cover more than just baccalaureate degrees?
Congressman, thanks for that question. Yes, as I mentioned a little earlier, the college scorecard that we've recently enhanced the data for now contains information at a field of study level for not only four-year colleges, but also two-year institutions, for some certificate programs, some graduate programs, and also has links to the apprenticeship programs through the Department of Labor. So we believe this is going to be a really good and important tool for students to be able to access and use as they consider future fields of study and future programs.
So prior to the previous administration, did they cover that broad range of programs available, or were they just focused on the baccalaureate degrees?
They were focused on four-year institutions and by institution level. Now we're down to the program level.
Okay, so what that would do then would be improving any student at any field of study, depending on how long
To
that
acknowledge
takes.
there are many pathways to a successful adult life, and we encourage students to look at all of their options and, in fact, look at them starting in middle school, frankly.
Okay. So your scorecard would actually protect more students than the previous administrations did, because you're including at the degree level and not the institution level, and you're considering all programs, not just baccalaureate.
Correct.
So you've done more to help students since you've been
I would argue
secretary than
that,
previously.
indeed. Yes.
Yes. Because if previously I'd been going for a two-year degree or an apprenticeship, I wouldn't have had that information available to me, correct?
That's correct.
Thank you for that. I appreciate it very much. Also, Secretary, has the information shared on the college scorecard been expanded? Of course, it's been expanded under your watch. Can you highlight what changes have been made, what the additional educational pathways are available? And I know you talked a little bit about that, but when you look at that, how do you think that's helped some of the other people that aren't going for a baccalaureate, but they're maybe going for a two-year associate's degree or a training program?
Well, this is relatively new, so it was just within the last several weeks that this data was made available. And so I think prospectively, students are going to be able to make better comparisons and to be able to compare between institutions, compare between programs, compare different kinds of fields of study, and again, just give students and prospective students many more tools to be able to make good decisions for their future.
I appreciate that, and I just want to follow up. I know there's been some previous remarks made about certain, students, and they haven't, but the courts have really held you up on getting relief to all students. Is that correct?
Correct. We had a process well underway in 2018, and the court stopped us from continuing it in May of 2018. And
So-
we've been waiting for the court on appeal since then, have developed a second methodology, and have just been able to unveil that and begin implementing it last week.
So really, the courts have caused some people's credit scores to be
Indeed.
harmed more so than the department.
Indeed.
Thank you, Madam Secretary.
Gentleman's time has expired. Gentlelady from Connecticut, Ms. Hayes.
Thank you, Mr. Chair. I'd like to return just for a moment to that January 10th, 2017 memo from the Borrower Defense Unit Undersecretary Ted Mitchell, who was a top lieutenant of former Secretary of Education John King. I just want to point out, while this memo was written before you took office, it serves as a fundamental transition memo between administrations. And I have the benefit of sitting next to a former secretary who assured me that there are meetings and a briefing book and letters. So I just think that it would be vital for you and your department to read what you inherited, especially since you were saying there was no plan. And, in fact, there was a plan, as this memo indicated. We operate in a country
There
where
was
there
not
are...
a process.
That wasn't a question.
I'll continue.
We
to-
operate in a country where we have peaceful transitions of power, and it's understood that we've changed from administration to administration. And then just the last thing I'd say before I move on to my questions is that it's been suggested by my colleagues on more than one occasion that I don't understand. This I understand. Everything about these hearings I understand. So Secretary DeVos, in March, you told Senator Murray that, and I quote, the department had decided to move forward with processing The department had decided to move forward with processing denials while awaiting the court's decision regarding the borrower's defense partial relief methodology. It turns out, in fact, that your department has been sitting on approximately 18,000 denial claims. My question is, why would the department purposely not inform borrowers that their claims had been denied?
First of all, the claims are ineligible, and we decided not to release a whole bunch of them early before we were able to implement this new methodology, because we didn't want to concern students that had pending applications that perhaps this was going to be the case for everyone. So while we could reach the conclusion and reach the decision for a number of them, we intentionally did not want to, I think, concern students with pending
Thank you.
applications,
But
because
don't
there
you-
are many pending applications that
got
will
it.
have relief.
I got it. But don't you think that a borrower who has no chance of getting forgiveness should be told their status? Is it unfair for borrowers to be waiting up to 4 years for a resolution when some of them may have in fact already been denied? The institutions have closed, they're losing access to critical documents, the interest is building up. Is there any, I don't know, political reason for doing that so as the number of denials would not be increased? If you have the
Again,
information.
we were concerned about the message that it would send to pending students with valid applications, and so that was the reason.
But wouldn't a student want to know if they're waiting for a decision? It's been 4 years and a decision has already been made that their application was denied. So that then,
I'm sure all students want to know, and that's why we are really focused on trying to get this new methodology fully implemented, and frankly have been very disappointed that the court has not opined on our appeal to the previous methodology.
but the court has not prevented you from informing students of denials. Is it not true that in a sworn declaration filed last month in court, that Principal Deputy Undersecretary Diane Auer-Jones stated that the department did not want to notify borrowers about the denials because of concerns about the public perception of the process?
Again, just what I said, we did not want students with pending applications to somehow think that their application was not going to have any chance of approval or of relief. And so now that we have the new methodology, it's kind of a moot point, actually. We are well underway with processing again, and we will be able to inform borrowers, hopefully many of them very quickly, with regard to the status of their application.
To me, this looks like a political decision because you aren't approving any claims. It would look bad if you were ratcheting up the denial rates, if the approvals were flat and the denials were up. So instead, you're just sitting on everything to keep better optics at the cost of students who just want a resolution. I'll ask again, if you know a borrower does not have a valid claim or that he has been denied for other reasons, what is the benefit of sitting on that information and not sharing it with the student?
I would like to refer us to Exhibit 6, which demonstrates the percentage of claims that had relief.
I'm talking about the claims that you know are denied.
I'm talking about the history of the claims that we were able to process before the court stopped us, and compare that to the percentage of claims that the previous administration, and they were consistent. You will see 62%, 62%, and so we have continued to.
My time has expired. I have to yield back. I'm sorry.
His time has expired. Gentleman from Georgia, Mr. Allen.
Good morning, Madam Secretary, and I thank you, too, for, I know that you and I share a common faith, and I think that's probably what sustains us in these things. Persecution is just part of it, and there is lots of disagreement on how to do things here. But I do remember, and of course, you know, we're in a different Congress, but and there are a lot of different new faces here and a lot of new ideas. But in the last Congress, we actually marked up the higher education authorization. And one of the most criticized pieces of that by my Democratic colleagues was a piece we put in there holding both public and private schools of higher education accountable to both students and the federal government for federal debt. In fact, we can go back and pull the records, but I'd like to enter the record of exactly that language that went in there, the vote on it, and the comments about it, making our schools of higher education more accountable, because obviously young people have been misled. I come across young people all the time, and you know, their first request is, could you please forgive my student loan debt, because they were ill-advised, and frankly, this thing kind of ramped up in the last, well, I've been a member, this is my third term, but I think began hearing about this about 10 years ago. Of course, the idea then is every young person should get a college degree, so the idea is, okay, we're going to loan people the money and not tell them how in the world they're going to pay it back, and that's wrong, and the federal government should have, I put the blame right here on this body. I mean, whoever came up with this idea in the beginning and did not put into place and provide for and to keep young people from being misled, that's the tragedy here. And I realize you inherited a lot of this. And so what I'm going to do right now, and General Brown, you've got some charts over there. If you haven't been able to share exactly what you're trying to do to correct this situation, I welcome that opportunity. You to have that opportunity. We got 2 minutes and 22 seconds remaining. If there's something over there that you think would help my colleagues here understand what you're trying to do and how quickly you're trying to do it, I'd be glad for you to share that with us.
The gentleman would direct the question.
All right, well, Secretary DeVos, if you would, whatever you have to do to defer to General Brown, or whatever, however you want to do that, please proceed.
Well, Congressman, thanks for that, and you are right. We inherited a difficult situation. We are trying to put in place a process, and we have now a second time put in place a reasonable process, one that treats students fairly, taxpayers fairly, institutions fairly, one that is balanced in its approach. And I will just stop and see if there is something that General Brown feels we have not been able to share with regard to that new process. But
Yes, ma'am. Just very quickly, I will show you on Exhibit 2 that, and while he's getting that up, just to correct one error here, 100% of those people who were impacted with credit report ratings have been corrected, and almost all, with very few exceptions, and those we're working today have had refunds given to them. We have a system of 11 loans.
I have to add one thing, and there was a mistake in my credit report that I didn't know about when I went to buy something, and it happens. Okay, so go ahead.
Yes, sir. I'll just quickly tell the committee that we have 11 loan services and 13 collection agencies across the country, and that those are not systems that work together. Those are individual silos of at least 4 different systems. So to get information from these systems, you actually have to go out to the individual loan servicers and craft the questions exactly right to get it back, which is not the way any of you do your consumer banking. It's not the way that most people do business in this century. So what we are trying to do is to take ownership of loan servicing back into federal student aid, so that there's one system that we own, so that if you ask us a specific question, we can get it from our systems without going out to the loan servicers, and therefore reduce the errors. We call that the next generation of federal student aid, and we are almost there. It's some of it we're implementing now, and most of it we will have implemented next year.
All right, Secretary, hang in there. I'm with you. Thank you.
Gentleman's time has expired. Gentlelady from Florida, Ms. Shalala.
Thank you very much. Thank you, Secretary, for joining us today. Secretary DeVos, you have repeatedly said that your new partial formula is necessary for individualized review of claims from defrauded borrowers. Is that correct?
yes.
Isn't it
Well,
true?
not only for individual, but just for a framework and a process.
All right. Isn't it true that your new partial relief formula does not allow for individualized review of claims?
No, it does allow for individualized review of claims.
You're sure of that?
Yeah, each claim is being reviewed individually by General Brown's robust.
So the partial review relief formula does allow for an individualized review of claims?
Yes. Yeah. I mean, each of them are being reviewed individually.
you wanna
That's
check?
why
Generally,
there are three times the number of attorneys that we've had previously.
Will the gentlelady yield? Ms.
Yes.
Shalala? Are you asking whether or not the individual case is reviewed, or whether or not the individual dynamics, whether that person's income is individually reviewed?
The latter.
Oh, well, no, it's a program-to-program review. So if a borrower has submitted a claim with regard to a specific institution and the program that they studied, the information, the median earnings information from that program, from all of those who graduated from that program at that institution, is reviewed against the median earnings of like programs from other institutions around the country.
So that's not an individualized review. You've set up a formula there.
It's individualized to program because as someone said earlier, you could have an individual who's done remarkably well financially that has made a claim against a program that, upon review, falls short simply because that individual has earned more. They should not be penalized in that case.
Okay, let me ask a quick question to follow up on with my colleague, and then I have another question. At what date are you going to notify the 18,000 people that have claims have been denied?
I believe that's been rolling out and continues to roll out, and General Brown would have that specific.
It's happening, ma'am, even as we speak.
And when will all of them be notified by?
That first tranche, I suspect they will be notified over the next couple of weeks, some of which have been notified.
All right, but when will the 18,000 be fully notified?
As part of that.
Over the next couple of weeks, ma'am, they will be. And it has already started.
All right. Let me ask a question. How many staff people does the general have for these individualized reviews?
I'm going to ask him to comment how he has staffed up at my urging the area reviewing them.
So, ma'am, we will have up to 64, and we have most of those already hired now. That's more than 3 times as many as we have ever had, the peak of which, if you go back over the last 3 years or 4 years, has been 14. We will have up to 64.
So, Madam Secretary, let me ask you a very specific question about this. So if he has around 60, and you have 227,000 claims that have to be individually reviewed, and you've already indicated that you intend to do that over 12 months, that's about 300 per person. Even the VA and Social Security, with the equivalent of a brigade, can't review that many. So explain to me how in 12 months you're going to be able, with that limited number of people, to process individually over 200,000 claims.
Well, General Brown has assured me that he has the personnel in place to be able to do that, and he has followed through on all of his commitments to me
Madam Secretary, that's
previously,
about 300 a day for an individual. That is technically impossible. The VA can't do it, Social Security can't do it. We have a lot of experience in government, so I'm questioning the credibility of being able to do that in 12 months, which you've assured us you're going to be able to do.
Again, I'm going to ask General Brown to comment more specifically on that.
So, ma'am, I would say that all claims are not the same. The complexity of some are far more than the others. The amount of documentation is far greater than the others. So we have people that have been working at this. They've looked at the various complexities. The number that we're at today for processing, we're very early in the process. We hope to grow that to a number that exceeds the amount that are coming in, and we're not stagnated. So if 64 is the wrong number, then we will hire more. We will go back to the Secretariat, ask for more resources, and we will look at the production on a weekly basis. So I would not get fixated on 64 other than to say that's greater than the amount that we have had in the past. We are looking at this each month, and if we need to bring on more
With all due
attorneys,
respect,
we
Madam
will.
Secretary, I'm focused on 200,000, not on the number of staff people. I'm simply suggesting that technically, given the number of staff people, you actually cannot process that number. And you ought to look at that. If I have one more
Congresswoman,
session.
if I could just comment, many of these claims have been adjudicated to the point of being able to be processed. So there are a lot that are already several steps into the process. Now they have to just complete the process.
I yield back.
Thank you.
Can't do it.
Who do you have next? Gomer? Oh, I'm sorry. Mr. Schmucker. Gentleman from Pennsylvania, Mr. Schmucker.
Thank you, Mr. Chairman. Thank you, Madam Secretary, for being here. Appreciate your work. Appreciate your comments earlier in regards to the need for congressional oversight, which you stated you understand the need for. You have done, I think, an excellent job of outlining your response and the department's response to the questions that have been raised legitimately here today. But I find it unfortunate that you continue to be asked about reading a specific memo, and that I don't understand what that has to do with your department policy on these issues, which is important that we understand. And in fact, the memo that you're being asked about was written in January 10th of 2017, prior to you taking office. So I just want to make that clear for the record. I also find it offensive earlier comments that were made in regards to your view of public education. Anyone who looks at your body of work and says that you don't care about children, doesn't care about public education, that's untrue, it's false, and it's offensive. I also find it offensive that the same statement was made about Republicans, and anyone can look at my record and others on the Republican side of the aisle and know that we have worked hard to ensure that every child gets the education that they deserve and that public education is working effectively in our states. So the committee has reached a new level when we are throwing those kind of accusations against the other side, and it's unfortunate, should not be part of a hearing here today. You do have, there have been some questions in regards to your authority and to the idea of partial, what's the word?
Partial relief.
Partial relief, I'm sorry. And I want to make this clear, and I want to ask you a question in this regard. Partial relief could be for someone who has already graduated from the institution and who is in the workforce, correct?
Correct.
We're talking about someone who may have graduated years before the school closed, who has had a beneficial education and has had a job as a result of that education. What I'm hearing Democrats say here today is they don't even want us to look into that. They want instead you to make a blanket relief, 100% of any additional student loans that that student has outstanding. Am I correct on that?
Well, there is, I know there is an attitude that many, if not all of the
No court
loans
of
should be
law, no
completely
court of
forgiven.
law would look at a situation like this. No insurance company would look at a situation like this. And for us to expect that taxpayers would support something along that line, I think, is not a good precedent. I do want to put a few things on the record. And I'm going to run down through a series of questions. So borrower defense, first, you agree it's a provision included in the Higher Education Act, correct? That statute in section 455H of the law states, notwithstanding any other provision of state or federal law, the Secretary shall specify in regulations which acts or omissions of an institution of higher education a borrower may assert as a defense to repayment of a law made under this part, except that in no event may a borrower recover from the Secretary in any action arising from or relating to a loan paid under this part an amount in excess of the amount such borrowers were paid. Those are the only provisions that restrict the activities that you can take in writing a rule. Am I right on that?
Correct.
My interpretation means this: one, that the Secretary will issue regulations on this issue, and number two, as I said, that's the only limit that you have in providing relief.
Turning to the rulemaking activity then, there are 3 different regulations. President Clinton's in 1995, President Obama's in 2016, and yours this year. Is that correct as well?
That will take effect next July, yes.
Yes, and the regulation applicable to the loan is dependent on the date the loan was dispersed?
Correct.
Under the 1995 Clinton regulations, did the regulations allow the Secretary to grant partial relief?
Yes.
Under the 2016 Obama regulations, was the Secretary allowed to grant partial relief?
Yes.
Under the 2019 regulations, was the Secretary allowed to grant partial relief? Do you believe that that authority is clear and not in dispute?
Yes, I do.
If members of Congress disagree with the policy decision, they defer to the department. Can they introduce and pass a bill mandating that you to provide full relief? And would you continue to follow the law that Congress has written if that were the case?
Congress could indeed pass that law, and if that law were passed, I would indeed follow it.
Thank you, Madam Secretary.
Thank you, gentleman. Yields back. The gentleman from Michigan, Mr. Levin.
Thank you. Good afternoon, Madam Secretary. I'm going to lead you, just to let you know, through some yes or no questions, just like Mr. Smucker did so ably. Let's see if we can get a yes or no answer over here as well. In a November 7th letter to Chairman Scott, you wrote the following in reference to claims from defrauded Corinthian borrowers, and I quote, "The clear intent of the prior administration was to eventually provide blanket relief without review of the facts and evidence." Does that accurately represent your views on the Obama administration's process for reviewing Corinthian claims?
Yes.
Okay, thank you. So I have in my hands here 2 memos that were uncovered yesterday in a story by National Public Radio. These memos, which were produced by Education Department staff in late 2016 and early 2017, show a detailed analysis documenting pervasive and consistent fraud by Corinthian schools. The committee's been requesting relevant documents from you for the last year. Did you provide these documents to the committee?
We have been providing documents.
Did you provide these documents, these 2 memos?
I cannot, I don't know what memos you're holding up, and
They're the memos that we've been talking about all morning, ma'am.
yes.
You don't know whether you submitted them or not.
The NPR memos that, yes.
Yes, did you submit them or not to us?
I'm sure that they were part of whatever
You're sure you did submit them?
document dump of 18,000 pages.
Would the gentleman yield?
Yes, I would.
We haven't seen those documents.
Okay, so you
Just
did
for the
not
records.
submit those documents to us. So did you halt and curtail loan relief for defrauded Corinthian borrowers without reading this detailed review of the fraud conducted by your own career staff by these schools?
Congressman, I had many discussions early on in my term.
So let me just ask you, do you know whether you've read these?
finish?
No,
Can I
no, you can't. Do you know whether you read these or not?
I had discussions about the previous administration's views and policy toward these pending
Okay, so let's move on to the substance of the memos. According to the memo dated October 24th, 2016, the staff at Corinthian-owned schools repeatedly lied to prospective students by telling them that their credits would transfer to other schools. The memo quotes one of the many similar claims from students. The student says, and it's on the screen here, "I was told my credits would transfer to University of South Florida for my BA in finance, and they did not. So I was stuck with all these loans, and no school will take them." Madam Secretary, does that sound like fraud to you? Yes or no?
Sir, we are considering each.
Okay, so let me go on. There's more. That same memo documents another form of fraud in which Corinthian schools repeatedly told students they were accredited when they, in fact, were not accredited. The memo quotes a claim from one student, typical of many, who says, quote, "There was speculation that the school was not accredited, but they continuously posted fake documents around the school, claiming that they were accredited and that any credits we received would transfer over without any problem." Madam Secretary, does that sound like fraud to you?
Congressman,
Will you go to the ends of the earth to defend a for-profit company that posts fake documents
Congressman,
on its walls?
I am not committed to protecting any institution, no matter what their organization is.
Okay, Madam Secretary,
I am committed to students.
All right,
and
let's
the
talk about
students
that,
that
Madam
have-
Secretary.
that
Let's talk
have-
about your commitment to students.
Can I finish a
No, you may
sentence,
not.
please?
The Consumer Financial Protection Bureau found fraud at Corinthian colleges. The state attorneys general of California, Massachusetts, and Wisconsin found systematic fraud at Corinthian colleges. The Career Education Department staff found fraud at Corinthian colleges. Madam Secretary, you appear to be the only person who does not believe there was fraud at Corinthian colleges. Can you state to me here whether or not you think Corinthian colleges committed any significant amount of fraud against its students?
Congressman, I know that there are student borrower defense claims pending for students that attended Corinthian
Do
College.
you think
And,
Corinthian colleges, we all know there are,
Mr. Chairman,
we all know that there are,
Mr. Chairman, if I can't answer a question,
so do you think, I'm asking about you yourself, after all these many months as serving as Secretary of Education, that Corinthian colleges committed fraud against its students?
The time of the gentleman has expired, and the Secretary will answer.
I know that there are Corinthian College students that have valid borrower defense claims, and we are committed to ensuring that each one of those is considered individually and that the relief is properly attributed to each student that has filed valid claims.
Thank you, Mr. Chairman. I yield back.
The gentleman from Texas, Mr. Taylor.
Thank you, Mr. Chairman. Madam Secretary, appreciate you taking the time to be here. Mr. Chairman, appreciate this hearing. And I'll just say that in my own experience, my general experience is when talking to witnesses, letting them know ahead of time that there's a particular memo I want to talk about or a particular issue that might be a little off the beaten path is generally really helpful to getting a good response, because then they have a chance to review it and read it. And the sooner you get it to them, the better the answers generally are and the more thoughtful they are. And also, I guess I was in the Texas legislature for a period of time and served on the education committee there, and I'm used to a more professional environment where people allow the witnesses to answer their questions. I generally find the answers are better if you don't cut them off. I just wanted to talk a little bit about the operational challenge that lies in front of you, Madam Secretary. So I believe your testimony is that there's been a 5,000% increase in the number of borrower defense claims. Did I get that number correct?
Yes, that's correct, Congressman.
And then over what period of time have you seen this 5,000% increase?
Since 2015,
Okay.
it was like a spigot was turned on.
Right. Well, and I'll just say, I served on the Homeland Security Committee, and we saw a similar crisis on the U.S.-Mexican border, a 3,000% increase in the number of families that were coming over the border over a very short period of time. And that, of course, creates an operational problem. How do you process all those people? And I think you have a very similar situation here, where a previous administration, for whatever reason, made a series of policy choices that then caused a massive increase, and then you're left, unfortunately, I think in some sense, to clean up the mess. Can you speak to how you have ramped up your operation to be able to handle this kind of increase? Because clearly you didn't have the ability to handle the situation as we find it now didn't exist in the previous administration. So you have had to create it whole cloth, a whole new process to handle this tremendous burden that's been placed upon you.
Well, thanks, Congressman. In addition to developing the initial methodology to considering the claims, federal student aid itself, I have hired General Brown, who has undertaken a review of the structure internally, has made some significant organizational changes for operational efficiency, and he has also, as you heard previously, stood up a threefold number of individuals that are committed to this specific area. And we will continue to adjust as necessary based on the claims that we have, with the hope that, frankly, we should be returning to the kind of level of borrower defense claims that were resident prior to 2015. From 95 to 2015, there were a total of 59 claims. I think that's what we should aspire to in the future, that students have the information they need, that institutions are very transparent about what their programs are, and that they are accurate in what they represent. And I think that we will all be in a better place if that's the case.
Sure, and I'll just make an observation that in my own time in working in the education space in the state of Texas, over and over again, articulation between a community college and a public university, which is what generally we were working with, articulation, getting credits to go from A to B is a real problem. And it's not just with for-profit schools, it's with community colleges, it's with dual credit classes, and it's even within public university to public university. And so this is something that certainly I've seen for many years. I was intrigued that those are some of the things that are claim of fraud. It's like, well, I've seen that all over the place in the public space for years. Is there anything you would like to add at this point? I know you've been cut off many times in this hearing, and it's unfortunate that you're not given a chance to answer your questions.
Well, Congressman, I would just reiterate the fact that nothing bothers me more than the fact that we've had all of these claims pending for as long as we've had. And I'm very hopeful that with the implementation of this new method, we will be able to quickly address and process through. And you know, I feel for the students involved, and I'm also very sympathetic broadly to students. And we want to make sure that students have good experiences and that they have good information in making decisions about their experiences.
Sure, and again, I just want to say I appreciate that you have basically been handed a mess and that you've had to create a solution. And it seems like you have created a solution that is going to address that in a timely manner. And I'm grateful to you for your service to this great nation and to the students of this country. Mr. Chairman, I yield back.
Gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chairman. Thank you for holding this hearing, and thank you, Secretary DeVos, for being here. Earlier this year, you repealed the gainful employment regulations that these Obama regulations evaluated programs based on earnings data, just like your partial relief formula. In repealing these regulations, the department wrote that gainful employment was quote, fundamentally flawed and an unreliable proxy for program quality. Gainful employment was a regulation to prevent low-quality for-profit colleges from obtaining federal funds. You're now using its data to evaluate colleges, exactly what you said it shouldn't be used for, but instead of using it against bad schools, you're using it to deprive students of loan relief. So, Secretary DeVos, which is it? Should we grade schools on earning data or not? If you can just give me a simple answer, yes or no, I'd appreciate it. Should we grade them on earning data or should we not?
Ultimately, no.
Okay, thank you.
Unless you're going to do all institutions equally.
Okay, thank you. So you're willing to, so we should not. So
Unless you're going to do all institutions equally.
All right, so you're willing to use earnings data to tell defrauded students that fraudulent schools they attend is high quality? Will you commit to using this data to tell students which schools are low quality by reissuing the gainful employment regulations?
No, we are moving ahead with a process to consider all of the borrower defense claims that are pending. And we are very hopeful that with the additional information that we have released for the college scorecard, that it's going to be a very important and useful tool for students.
I need to reclaim my time because I really want to get through my questions. So it doesn't sound like you're interested in doing that. Secretary DeVos, gainful employment data only speaks to the outcomes of those who graduate. I was a college professor for 40 years. So I've worked with students. I know the struggles that they have. I even had student loans myself. But we all know that many students who attend an institution like Corinthian, I know it's continued to come up, don't graduate. They drop out with a significant amount of debt. So how is it possible that a metric that speaks to the outcomes of graduates only is being used to determine the level of harm for those who dropped out? Just using that one metric. Well, how is that?
Congresswoman, we believe the methodology that we have just implemented is one that is very scientifically robust and one that is going to ultimately treat all of the pending claims fairly and will answer students' questions about whether they have had financial harm ultimately.
Okay,
or
let me move on. So in your statement regarding the new partial relief formula, you said, and I quote, "We cannot tolerate fraud in higher education, nor can we tolerate frivolous giving away taxpayer money to those who have submitted a false claim or aren't eligible for relief," end of quote. Yet the new partial relief formula is not about those false claims or those who were ineligible for relief. So what possible rationale would you have to deny the full measure of relief to students who we all agree have been defrauded and left worse off?
Every student claim is going to be considered, and if they've received financial harm, demonstrable financial harm, that will be relieved at some level.
Okay, I am concerned that we are one data breach away from hundreds of thousands of borrowers' private data being compromised. So the department's Borrower Defense Unit is currently in possession of private data from hundreds of thousands of students. So are you taking the appropriate steps to protect the personal data of defrauded borrowers?
I'm very concerned about data security for all students, and that is a high priority for me and my department and for federal student aid.
Are you taking any
We are-
steps?
We have taken steps ever since I've been in office to ensure the protection of data, and that is not a one-time process, and it's not an episodic one. It is a
Thank you very
continuing
much.
one.
Let me just make this assessment. Given the errors that you and your servicers have committed regarding borrower defense data and just borrower data in general, can you commit to reviewing the security of that data and reporting back to this committee to assure that current and future applicants and their data is being managed responsibly? Can you commit to that?
Yes, I commit to that,
Great.
just as I commit to continuing to be responsible for and responsive about data security across the board.
Thank you very much, Mr. Chair. I yield back.
Thank you. The gentleman from Wisconsin, Mr. Grothman.
Yes, first of all, I'd like to thank you one more time for, over here, thank you one more time for taking this job. I mean, you knew you were inheriting a mess, and you know, I'm just looking at the student loan debt. I think under the past administration, it more than doubled from $6 billion to 1.3 trillion, and I don't mean to be partisan here, it almost doubled under the Bush administration as well. So this institution and prior administrations allowed the student debt to get completely out of control. They should have known a mess was here, and you're the one who's stuck cleaning up the mess. So thank you for trying. I know this isn't the only mess you have. I know there's been fraud in the income-driven repayment program. I know there's the public loans service, the public service loan forgiveness program has problems, all of which you inherited. So again, we all know you didn't need this job, and thank you. I'm going to ask a couple questions. As I understand it, in the past, they've been advertising that your student loans may be eligible for forgiveness, right? Is that so?
That's my understanding as
Yeah,
well.
Facebook ads, that sort of thing. And obviously, if you look on and say, wow, you can get your loan forgiven, there are going to be all sorts of people lining up to do that. And of course, some of those claims will be legitimate, and some of the claims won't be legitimate. Have you guys uncovered any instances of unfounded claims filed by borrowers?
Of claims that are not valid?
Right. I think there are a lot of people out here just want
Yes.
to forgive everything.
There are many of them.
Okay. You want to elaborate that on it at all?
Well, there's different kind of invalid or, claims that cannot be in any way relieved financially. Some of them fall outside the bounds of the various rules and times of submission. Some of them are clearly not based on anything close to fraudulent. I referenced the one about I didn't, my professor was mean, or I didn't like my professor. I'm sorry, that's not a valid claim for your student loan relief.
Okay.
So it's a wide variety.
But it's certainly indicative of why we just can't forgive all loans.
Correct.
How are you mitigating cases of baseless claims in borrower defense? Are you doing anything to mitigate that?
Well, I'm very hopeful that as we implement the new rule and continue to work through the processing of these claims, that the conversation around this is going to be much more around ensuring that those students that actually have a claim of financial harm are the ones that are getting relief, and that we will have fewer than 1,200 plus applicants a week accruing in the Federal Student Aid Department.
When fraud is committed, do you have the right to go after any of the colleges and universities that committed fraud?
Well, I think that's a very important question, and unfortunately, the bulk of a large volume of the pending applications are from institutions that have closed, and in that case, obviously, it's a different situation. But for those institutions that are found to have valid claims that are still operational, the schools would be the first place to go. The taxpayers shouldn't have to be footing the bill in the case that the institutions still exist.
You think it'd be better if this institution did something in the future to make sure those loans didn't get so high in the first place? Or I guess I'll put it this way: if this institution would do more to educate young people that not every student loan is a good student loan?
There are many things that both Congress and writ broadly, we all can do to ensure that education experiences in the future are entered into with more thought and more wisdom.
Okay. You have new regulations coming out. Would you like to elaborate at all on how your new regulations protect the students, but the taxpayers and the institutions all at once?
If you're speaking about our new
The new
borrower
ones, yep.
defense regulation, it really does protect students, taxpayers, and gives institutions an equal footing. It treats all institutions equally. It's I think, a much better and more balanced approach to this issue, and one that will continue to let students file and make valid claims, and give schools the opportunity to review and respond to, and students respond back. I mean, there has to be a due process component for institutions, and frankly, we need to have a more tight definition of what constitutes fraud or misrepresentation, which is part of the 2019 rule.
Thanks, and I'd like to apologize for some of my colleagues. We got a big swamp here who sometimes are a little bit intemperate, but thank you for coming over here today.
Thank you. The gentleman from California, Mr. Harder.
Thank you, Mr. Chairman. Secretary DeVos, I want to start by telling you a story about my constituent, Artemisa. Back in 2009, she became a student at Heald College in Modesto, just months after it was purchased by Corinthian Colleges. Artemisa wanted to make a difference in her community. She was pursuing a medical assistant degree. She chose Heald because she saw on the commercials that it had an 85% job placement rate. Seemed like a good investment. But then she graduated and she couldn't find a job. And now she owes a whopping $40,000 in student loan debt for a degree that hasn't helped her get hired. That may not seem like a lot of money to you, Secretary DeVos, but in the real world, that's devastating. Turns out, Artemisa wasn't alone in not being able to find a job. Corinthian colleges across the country lied about their job placement rate. They told her it was an 85% job placement rate for Heald. Turns out the actual rate was 0. Not 85%, 0. That's a big difference. Artemisa and tens of thousands of students were defrauded by Corinthian. We all know this. We all agree. In 2014, the Department of Education fined them $30 million for this fraud. Everyone agreed. But here, 5 years later, Artemisa still has that $40,000 in student loan debt. She still hasn't found a job in her field, and she hasn't gotten any help whatsoever. The reason for that is because you have put roadblock after roadblock in front of helping these students. Your job is to fight for them, but instead, your actions suggest you would prefer to be the chief lobbyist for the predatory schools that defrauded them. After being ordered by a federal court to stop collecting debts from cheated Corinthian students, you ignored the order and kept stealing money from these students. You were even held in contempt of court because of it. You're not standing up for them. You're working for the schools that defrauded them. Maybe you've forgotten to refund these students. Maybe Artemisa's $40,000 in student loan debt just doesn't sound like a lot to you because it's only 0.1% of one of your family's 10 yachts. Artemisa and tens of thousands of others have been waiting years for your help. You have deliberately violated a federal court order, and I'm confused why. So I guess I just have one question for you, Secretary DeVos. Are you deliberately violating this federal court order because you are too corrupt to uphold the law, or because you're too incompetent to do your job?
The gentleman will address the facts and figures and not question the character of the witness.
Secretary DeVos, why have you been held in contempt of court?
Well, Congressman, let me begin by saying I took great personal offense to everything you just said. I come to my job every day on behalf of students. I don't need to sit and listen to what you just spewed out of your mouth.
I don't understand how you can take...
I did not defy any court order. I instructed federal student aid to follow the court order. If you had been here earlier, you would have known that mistakes were made on the part of federal student aid employees and on the part of loan servicers that when they were discovered were immediately acknowledged and corrected.
Secretary DeVos,
They have
reclaim
been
my time,
remediated.
please.
They
I
have
understand
been
that you've been
remediated.
held, that you are taking offense. The reality is there are tens of thousands of students whose financial futures have been ruined by 3 years of inaction. And you're just making excuses. You're blaming this problem on somebody else. You've been Secretary of Education for 3 years. And you are trying to defy the facts of this matter. Yes or no, were you held in contempt of court and fined?
Congressman, I have not been able to address all of the Corinthian College claims because a court stopped us in May of 2018.
That's simply not true.
That is true.
The courts said there was nothing stopping the department from processing these borrower defense claims.
There was something stopping. There was a lack of process. The court said we could simply forgive them all, but that was not the right answer. The right answer is to do what's right for students and to do what's right for taxpayers. And that is my goal, and that is going to continue to be my goal.
What's right for students is helping the tens of thousands of students who have been defrauded, students like Artemisa. And blaming this problem on somebody else, taking 3 years to make absolutely no progress, it's not helping these students. It is only helping the scam colleges that defrauded them. Thank you, Mr. Chairman.
Where students have been financially harmed, they are going to have relief. We have a new methodology, which once again, if you had been here earlier, you would have known. We have just implemented it last week. We are beginning to process them again, and students will be considered, their claims considered individually, and I am looking forward to addressing all of them. Nothing disturbs me more than all of the pending claims that have been there and that we have not been able to address appropriately.
The gentleman's time has expired. The gentlelady from Nevada, Ms. Lee.
Thank you, Mr. Chairman. Thank you for being here. This is quite a mess. I wanted to ask you, this is an important issue in my state. In the past 10 years, 30 for-profit schools have closed. In fact, a year and a week ago today, Brightwood College closed in Las Vegas. And as we saw with Corinthian colleges, ITT Tech, ECA, schools with shaky financials are often completely reliant on federal student loan dollars. And when they collapse and declare bankruptcy, it is us, the taxpayers, as well as thousands of students who are left high and dry. So I really want to, in my line of questioning, get to how are we going to prevent this from happening? So I wanted to ask you just a simple yes or no question. Do you believe it's important that the department have information about the financial conditions of colleges?
Yes, it is important.
Thank you. You spoke many times today about protecting taxpayer dollars, and I could not agree with you more. Yet I'm feeling that a lot of the tension in this room today is because there's concern about protecting taxpayer dollars from frivolous BD claims, or like I'd like to focus on how do we protect taxpayer dollars from these fraudulent predatory schools and prevent this from happening before we throw thousands of students into turmoil. And so I want to ask you a second question. Isn't the point of financial responsibility monitoring to predict school closures before they happen so that something can be done proactively to protect the taxpayer dollars from going to those institutions through student loans?
Well, Congresswoman, let me just say, first of all, I think levying a claim of predatory against any school that is organized.
Well, I'm talking about schools. I want to define what fraud means, okay? Because it's been used here a lot today. The definition is the wrongful deception intended to result in financial or personal gain. And it is not lost on anyone here the preponderance of for-profit schools in the education space and for-profit schools that are now publicly traded companies. So there is a for-profit motive. There has been fraud, and that students have been left on the hook. And so my question was simply yes or no. Do you believe that the point of the financial responsibility monitoring is to predict?
To the extent possible, I think that's probably desirable, yes.
Okay, I agree with you. I think that is the purpose. You want to predict that these schools are shaky operators, that they might be fraudulent because there's so many kids that are going to these schools and not able to come out and have a job, and therefore defaulting on their loans because they didn't get the jobs that they were promised. And so that's the purpose of these triggers and these rules, is to predict it so that we're not sending taxpayer dollars to these schools and then they go bankrupt and the kids can't pay them and then the taxpayers pay it. So,
and the same is true
I want to go to one-third.
There's lots of institutions that.
I understand. I understand there are great institutions. This is really about ferreting out the bad actors in the space. And, I think the lesson for all of us is the regulations that we enact here have consequences intended and unintended, which had led us to this situation where we have had thousands of for-profit schools close. 80% of the school closures are for-profit schools. And many of these are bad actors, okay? And by the way, it's minority and low-income students who are being preyed upon in these cases. So I really just want to get to one other question and talk about some of the changes that have been made to your borrower defense rule, specifically around what these triggers are to identify if these schools are eventually going to go under. And under the 2016 rule, publicly traded for-profit schools were required to report any incident or occurrence of an SEC filing or a warning letter against that institution. And can you clarify this? Under the recent rule that was issued, isn't it the case that an institution would only be required to report that when the SEC suspends trading of that stock or if the stock is delisted from the exchange?
There are changes in the reporting requirements for financial measures for an institution in the 2019 rule.
Okay, so
there are a number of different measures that are required, and there are triggers that will happen to send up flags if an institution is in jeopardy. I think it's also important to distinguish, to acknowledge the fact that.
Okay.
Gentleman from Pennsylvania, Mr. Muser. I apologize for being a little abrupt there. Expect to call votes shortly, and we have several members that are still trying to ask questions. Gentleman from Pennsylvania.
Thank you, Mr. Chairman. Thank you for your professionalism and decency as always. Madam Secretary, nice to see you very much again. I want to thank you for your service. Clearly, you worked very hard, and you've made a lot of progress, which I want to ask questions about and outline. And if people had any idea of what your background really was, the level of work and philanthropy and good that you've done, maybe they'd act a little bit more civilly, but perhaps not. You know, these hearings are supposed to be about ideas, not insults, right? Solutions rather than salvos, reality rather than revisionist history, and questions rather than accusations, actual problem solving rather than pointing out problems. But I guess that's just a tradition around here lately. So I would like to ask you, when you became secretary 3 years ago, my understanding is back in 2015, the number of claims and problems and escalated tremendously. And there were a number of reasons for it. One of them was at Vistria, where, lo and behold, the former number 2 in the Obama Education Department, Deputy Secretary Miller, who left in 2013 and became a partner and chief operating officer at Vistria, who was on track to become chairman of the university's parent company if the sale went through, had a little, that is just when Vistria had all its problems began. Would you say that was a contributing factor to this unbelievable escalation in claims and problems?
I think it's certainly possible that it was a contributing factor.
Well, what were the number of claims? What was the number of claims under the Borrower Defense Repayment Rule? It's increased exponentially in the last 4 years. Do you have any numbers on that?
Well, from 1995 to 2015, there were exactly 59 borrower defense claims made. And since then, that number has increased 5,000% to now nearly 300,000 claims.
And when did those increases begin?
In 2015.
2015. So 2015, 2016, that was the Obama administration. We don't want to revise history here. You came in January 2017.
February, but
Right.
close.
February. Dealing with a mess, a nightmare situation. And what did you do to work on this situation, you and General Brown?
Well, when
He wasn't
I
there yet.
took office, there were 64,000 unaddressed claims from the previous administration. It was clear that promises had been made to approximately half of those, and we followed through on the promises immediately. I also asked the Inspector General to do an investigation into what the process was for considering these claims, and that yielded some significant deficiencies in in other words, there was no process. So we set forth to put a process in place to be able to consider each claim for its merit and its validity. And we implemented that in early 2018, and we were well underway with processing the pending claims, and we were stopped by the court in May of 2018, based on the data we were using, not on the approach to the relief methodology. Since then, we have been waiting for the court. We've appealed it. We don't agree with the court's decision. It's been appealed. We're still waiting. And in the meantime, we implemented another methodology, which we just were able to begin implementing last week. And it will, we hope, be able to address the claims, the pending claims, very expeditiously.
How many deserving claims were received relief this past year or the year previous under your jurisdiction versus 2015 or 2016?
Well,
how many more people were helped?
Yeah.
How many more people received loan relief under your jurisdiction and General Brown's versus your predecessor?
So the percentages of claims of students' claims that received relief were the same between the previous administration and the ones that we've been able to process thus far There's a chart here that shows 62% were approved during the Obama administration, and we've continued at that level of approval.
62%, but with many more claims, so more people were helped.
Correct.
Thank you. I yield.
Thank you. The gentleman from Maryland, Mr. Trone.
Thank you, Madam Secretary, for your service. I know public service can be very hard, but of course with it, comes an accountability to help these young students who have been defrauded and help them, if we can, in a timely manner. Before coming to Congress, I was a CEO of a business with over 7,000 employees. I know how important people are to any organization. At the end of the day, the buck always stopped with me to make sure we had the right staff to serve our customers. So let's talk about staffing, if you don't mind, under your leadership. To follow up on what Secretary Shalala was touching on a bit ago, within the first year in office, you actually cut the staff in the Borrowers Defense Unit. In that unit, during the first year, by 75%, from 29 people to 7 people. While this might make great sense that we saw a decrease in the number of claims, the opposite, as you've clearly stated, is actually the opposite. We saw a dramatic increase in claims from 54,000 to now, as General Brown said, over 300,000 are out there. So when my business had more work, I hired more people. So why, when you had in the past this dramatic increase in borrowers' defense claims, did you decide to cut jobs instead of hiring more people to do that work?
Congressman, good question. We had significant attrition when I first came into office, and since then I have instructed and urged General Brown to staff that segment of the Federal Student Aid Office to the extent that we need to be able to address these claims, now that we again have a process to be able to unveil and to implement.
And that's great. I guess the question is still there, is that now, 3 years later, we were actually at we were actually at 7 people at one point, according to the public document on March 31st, 2019. You had 7 employees remaining in the Borrowers Defense Unit.
Well, we were processing the claims under the previous methodology, and that was moving along well. When the court stopped us,
I've heard about that, and I've been here the entire time, and I respect that. There's still 300,000, as General Brown said, folks nationally who are paying the price because the department, I think, has intentionally slow-walked this by not having enough staff to process those claims for literally over 3 years now. It's been 3 years. Do you believe that the insufficient number of staff in the past 3 years has contributed to the department's inability to process these borrower defense claims?
no, sir, I don't. It really has been the court decision that stopped us from
But the
continuing
court decision,
process.
and I know, we've talked about that, the court decision did not stop you from continuing the process. You could have continued the process while you went through the appeal. Let's talk about the facts a second.
Only if I was going to say, yes, full forgiveness, or no, you don't qualify.
And I'm guessing there's a lot of full forgiveness out there, given the horrible work that Corinthian and others
But
did.
we couldn't use the data. We couldn't use the data that we were using, so.
Let's look at the data.
practically
Let's look at the
speaking, we
data
could
a
not
second.
process.
Let's look at the data a second. So on March 31st, if you have 7 employees, how many claims does an employee process in a 40-hour work week?
That is not a relevant question, because we have not been able to process.
No, how many? It's really, really relevant, because
No,
you got to have the
because
people
since
to
May
do
of
the work.
2018, we have not been able to process.
You have
since
to have the
May.
people to do the work. Right now, you talked about ramping up the 64. And so
we
you're
have.
clearly ramping up with the people, because now you said, whoa, we missed the ball. We saw that in 2016, it went through the roof, the claims did. You got hammered, but while you were cutting back to 7 people, now you've done a hockey stick and ramped it back up to
Sir,
64.
It's a convenient narrative, but it's inaccurate.
But the only way you're going to figure out staffing is how much work is there to do, how long does it take them to do that work, and then I can do my staffing model from that.
And we have continued to staff up, and will continue to add to that if necessary to process the claims now that we have been able to implement the new methodology.
We appreciate that. General Brown told the staff that since you've been in office, about 50,000 people have had their claims reviewed. With there's 300,000 out there, at that current rate, it's going to be 15 years. For the first 3 years, it took you to do 50,000. These young people wanted to be educated, but they were lied to by these institutions, and I think the response has been a bit to run out the clock, a bit of tough luck. So we just need informed decisions based on the data and keep focusing, if you could, on the customer. Thank you.
Gentleman's time has expired. Gentlelady from Michigan, Ms. Stevens.
Thank you, Mr. Chairman. Secretary DeVos, we're here today to provide the public with a full understanding of the department's failure to provide defrauded borrowers with a relief they're legally entitled to. I would like for you to know a fellow Michigander, Erica, someone I've had the privilege of getting to know. When she was a child, she wanted to become a lawyer. And growing up, she faced multiple challenges, as many Americans do. She ended up dropping out of high school, but still managed to get her GED at 21 while raising 2 children. And she saw a commercial one day for Everest College, a Corinthian college, in 2011. And she was recruited into the school's paralegal program. The recruiter told her that in order to become a lawyer, she had to be a paralegal first. Erica was ecstatic to go back to school. She earned a 4.0 while she was there. And after her first year, she took that next step. She contacted a law school to learn what she had to do next to become a lawyer. And that's when she learned that Everest was not considered a legitimate program. And she felt cheated. She was saddled with student loan debt and realized that the best choice she could make for herself and her family was to cut her losses and leave Everest. Secretary DeVos, do you think Erica made a mistake in attending Everest?
Congresswoman, I can't comment to her decision there, but I certainly can feel for her if that story is accurate, and I look forward to, if she's among the BD claims pending, making sure that we can address it promptly now that we have been able to start the process again.
Would you have advised Erica to continue attending Everest?
I can't comment to a hypothetical like that.
Erica is currently not working either as a paralegal or a lawyer, but is instead living paycheck to paycheck with no way to pay for more school to pursue the career she wanted and dreamed of. And she's now in her mid-40s. Do you believe she received any value from the education she received at Everest?
Again, I can't comment specifically to her situation. The story as you tell it is one that I certainly feel for.
Erica applied for borrower defense in May 2015 and had her loans placed into forbearance. 3 years later, the department finally approved her application, but then denied her a full discharge. And it said that they would only relieve 50% of Erica's loans. Why did she deserve to only have 50% of her loans relieved?
Well, I have to assume from what you've told me about her story that we were considering her under the first methodology that we had utilized, and that the program she attended, the earnings information from that, others that had graduated from that program were compared with earnings from like programs of other schools across the country. And that was, again, a formula and process that was put into place to consider each student's claim individually and uniquely.
Despite a court order, Erica's servicer started illegally collecting on her debt in 2019, this year, and she became extremely worried when she saw all of her loans were back in repayment because she knows there's no way she's really going to be able to pay them. What's stopping the department from taking action to protect the hundreds of thousands of students like Erica who were cheated in this predatory way by these institutions?
Well, again, I can't comment specifically to her experience right now. I'm happy to have General Brown's team look into it. If
That would be
you
great.
give
And
specific
I know Erica
information.
would, excuse me, I know she would love that. And she said to me when I last spoke with her, she said, you know, the one thing I really want to do is make a difference for future people and make sure this doesn't happen again. And, you know, I had a little bit of time to read through your testimony, and kind of buried in there are thousands of stories like Erica's. And she did want me to share this story, and I appreciate you both taking it to heart. And hopefully we can all continue to step up to address this for all Americans, all Michiganders, so that they have the opportunity to pursue their dreams and provide for their families going forward. And with that, with Mr. Chairman, I'll yield back.
Thank you. The gentlelady from Massachusetts, Ms. Trahan.
Thank you, Mr. Chairman. Secretary DeVos, thank you for being here today. 2 days ago, you announced the department's new formula for calculating relief for students who have been cheated by fraudulent, predatory for-profit colleges. This formula would take median earnings and subtract from it 2 standard deviations to determine the amount of one's borrower defense discharge relief. Now, that's a lot of jargon. So I wanted to just try to put it into an example, just so it made sense to me. So a young woman, and we'll name her Betsy, gets her diploma in business and administration and management from Corinthian. And it says here on this chart that the median comparison earnings for that degree is about $18,000. And 2 standard deviations is about $20,500. I mean, not to put you on the spot, but do you know what 18,000 minus 20,500 equals? I hate public math. It equals negative $2,500. So using the new formula, you're basically telling us that in order for someone like Betsy to get full relief for the debt that she unknowingly incurred from a fraudulent institution, she would have to earn negative $2,500. Does that sound right to you, using your formula?
It does not.
Because that's what the numbers bear out. The Department of Education calculates the median earnings of Betsy's peers in her program at roughly $11,700 to determine the percentage of relief that she will receive. Any idea what the federal minimum wage is right now? We're trying hard in this committee to raise the minimum wage, but today it stands at $7.25. So look, I just want to, if Betsy earns $11,700 on an annual basis, that means her hourly wage is $5.63. That's $2 below the federal minimum wage. So I guess, it's astounding to me, but I think what you're telling me is that student borrowers like Betsy, who graduate from a fraudulent program and earn $2 less than the federal minimum wage, can only get 25% of their loans forgiven because they didn't have negative earnings.
No, Congresswoman, I don't think the story you're using here is an accurate one.
I trust my math. I poured over several examples, and I used your 2 standard deviations. I don't have confidence in much, but I have a lot of confidence in the formula and how I used it for Betsy's use case. Look, the new partial relief formula that you came out with 2 days ago, it doesn't benefit students who've been fleeced. It doesn't take into account individualized earnings, debt load, whether Betsy is back in a full-time or part-time accredited college program, which is why my friend from Pennsylvania, Representative Wild, and economists alike call it nonsensical. These are students who wanted nothing more than to get ahead, who took out loans in good faith and they were taken advantage of instead. And your response to them is to cheat them again. So I know right now you have the authority to provide full, fair, and immediate debt relief to student borrowers who were defrauded by these predatory colleges. And every day that goes by is a violation of students' rights. And frankly, it's criminal. There are hundreds of thousands of innocent students with pending claims. That includes almost 3,000 in my home state of Massachusetts. On this committee, our focus is creating opportunity and value for students with high-quality, affordable education. The formula that you've developed, it's too little by far, and it's too late, and it doesn't demonstrate your commitment to our students. I yield back.
Mr. Chairman, if I could respond to that a moment.
You can respond, please.
Congresswoman, I am committed to treating each of the students who have filed borrower defense claims fairly, and we believe that this methodology that has been developed is one that will treat each of them as an individual and will look at their program of study. If you are advocating for 100% loan forgiveness for all students who claim borrower defense claims, you have the power to get a law passed in this body, and I encourage you to do so. If you pass that law, I will enforce that law.
The formula, the way it's designed right now, it takes in median program earnings from other people who have been defrauded. Therein lies the problem. That is not a formula that makes sense when you're taking into account kids who have taken out loans, who have to go back to college, go back to school, to an accredited program. Their debt load is already sinking them, and now they're taking on more. Your formula is flawed.
I guess we'll have to agree to disagree.
Gentlelady's time has expired. Gentlelady from Minnesota, Ms. Omar.
Thank you, Chairman. Secretary DeVos, thank you so much for being here and giving us the opportunity to have this conversation with you. I am curious if you're familiar with the Minnesota School of Business and Global University.
I'm not familiar with that specific school.
Okay. Do you know that they were found to be engaged in consumer fraud?
If they were, I'm assuming there are some borrower defense claims pending for them.
Okay. So let me just enlighten you. We've sent you many letters from our delegation. In my district in 2016, the courts found that Minnesota School of Business and Global University engaged in consumer fraud and purposefully deceived their students by misrepresenting the job opportunities that would be available to their criminal justice graduates. Madam Secretary, that same year, your department independently reviewed the evidence and came to the same conclusion as the courts. The students were blatantly misled and taken advantage of. 1,336 Minnesota students were systematically misled to believe that they will obtain a degree and credits that were essentially meaningless, losing not only $33.8 million, but their time and countless opportunities. Let's take a minute to just imagine if these weren't just students. Let's imagine that they were corporations. The administration and our colleagues on the other side of the aisle, and probably you, would be up in arms. Corporate executives would not only get their debt forgiven by our government, they would also get compensation for their lost time, lost opportunities, and psychological distress. But Madam Secretary, you don't seem to be up in arms. Nobody seems to be concerned with what's happening with these students. Students who do not have access to corporate attorneys to make their case. Instead, they are struggling to make ends meet as they continue to face accruing interest, negative credit reporting, and the inability to restart their education, all the while hoping the government will do the right thing. I'd like to request unanimous consent to enter into the record 2 affidavits.
Objection.
These are from my constituents Whitney and Cheryl Stellan, whose borrower defense applications have been on hold since January of this year. Between the two of them, they have approximately $78,000 in crippling student debt. To make matters worse, once a borrower defaults, the consequences are severe and results in a snowball effect where a borrower might lose their eligibility to receive additional federal student aid and see devastating effects to their credit. Memo after memo, the Education Department career staff sent you memos that indicate that these students deserve nothing less than full relief. I know that you've said you haven't read these memos yet, but reports have come out, and I would have expected that you would take the time to read them before appearing before us today. I ask for unanimous consent to enter these 3 memos into the record.
Without objection.
I feel like you should be ashamed of the fact that you don't have answers to these memos, that you haven't looked at these memos, that you haven't taken the responsibility that you have as a leader to be prepared to give us a response. And I think the public should be ashamed that they have a Secretary of Education that's not putting the interests of students before the interests of the wealthy that are benefiting from defrauding these students. I yield back.
Mr. Chairman, if I may respond.
Thank you. The gentlelady's time has expired. Secretary can respond.
Congresswoman, with all due respect, I am very much focused on doing what's right for these students. And the memos to which you're referring preceded me, and they may have been relevant to conversation about how we proceeded with policy, but administrations changed and policies change.
They are precisely relevant to the conversation you were preparing to come to talk to us today. And in your preparation, you should have read those memos. I yield back.
Gentlelady's time has expired, and I recognize myself for 5 minutes. First, a lot has been said about whether or not this applies to for-profits, private, nonprofits, or public. The fact is, we have several 100,000 complaints of fraud for Borrowers Defense for the public colleges. How many public, nonprofit, and public institutions have been subject to allegations of fraud?
How many? I don't have the specific breakdown here. I'd be happy to get back with you
Do you have
on a
very
question
many?
for the record.
Do you have very many complaints from public colleges?
There are quite a few. I mean, it's frankly surprising
If you
the
can-
number
if you can get that to us.
claims that have been filed from like surprising institutions. So
You've also indicated that you've remediated the credit report problem.
yes, we've remediated the problems that it
Okay,
occurred.
Does remediate mean you've corrected the credit reports, or that you've reimbursed people for loss of job or higher interest rates they might pay? Or did you just correct the reports?
Whatever the issue was, we have remediated for, with the
Does that mean you-
small exception of those whose addresses we can't track down.
Does that mean you've corrected the reports or compensated people for lost jobs or higher interest rate they may have paid for a diminished credit report?
We have corrected or remediated their credit reports
Just
if it's a
just a credit
specific
report.
credit report question.
Are you aware that the University of Phoenix recently agreed to a $191 million settlement?
I understand that, and I also understand that the leadership there are formerly lead employees, political appointees of the Obama administration.
That's fine. How many, did that settlement involve federal student loans?
I imagine that there are some federal student loans involved there.
Were any federal student loans involved in the settlement?
General Brown?
Have there been, excuse me, General Brown?
Not that I'm aware of, or
There
that
are,
we've been, that
there
we
are
visibility.
requests for borrowers' defense from the University of Phoenix. About 8,000, is that right?
Right now, today, we have 14,000 of those borrower defense claims are from the University of Phoenix.
Okay, what is the status of those?
Those applications are in various stages, depending on when they were received.
Has any relief been granted?
I do not believe that, I can get that for the record and provide it for you, sir.
Okay, now, as I understand it, if you've been defrauded, you should get relief if you have suffered financial harm. And we've had the back and forth about how you establish financial harm. If you have two similar schools and you have your comparison group where they did not lie and cheat and defraud the students, they just acknowledged that the credits weren't transferable and you weren't going to get a job, but people went anyway. And you have another school that in fact defrauded the students, lied to them about accreditation, lied to them about transferability, and lied to them about job placements. Is it true under your formula you'd get no relief because you don't show financial harm?
Mr. Chairman, the methodology looks at all programs across the country that are like programs to the one that the borrower is making the claim against.
Right. And if the one you're making a claim against, in fact, defrauded the students, where the comparison group did not lie about the placement rate, didn't lie about accreditation, didn't lie about transferability of credits, and ended up with the same income as the one that in fact defrauded the students, is it true that under your formula, the students that were defrauded get no relief?
If there is no financial harm to that to the student making the claim, that would be correct.
Okay. And is it, I think we established that there's no individualized consideration. It's considered by class. If you went to that college, if you make a lot of money or you didn't make any money, you'd get exactly the same relief.
The claim is against the student debt against that school and program.
Okay. Can you briefly describe what the department admitted to when it admitted to gross negligence in the lawsuit that provoked the contempt of court?
Well, I think those are attorney's words. What we have acknowledged.
The department
What we have
admitted
acknowledged is
gross
that there were human errors made at federal student aid and with our student loan servicers, and that we acknowledge them, we take responsibility for them, and we have corrected them.
Defendants respectfully submit that the department's compliance report undersigned counsel's representation in the October 7 hearing, and the further information contained in this brief established that compliance errors at issue here were not the result of any willful or intentional conduct, but, as the court has recognized, gross negligence, including negligent oversight of the department servicers. My time has expired, and I yield to the gentlelady from North Carolina for a closing statement.
Thank you, Mr. Chairman, and I want to say publicly thank you for your response to what I considered inappropriate comments made earlier. I very much appreciate your response to that. As we agree, oversight, and I said earlier, oversight's important, and I stand ready, the Secretary has said she stands ready to work with the chairman to conduct good oversight of not just the Education Department, but every venue we have any jurisdiction over. But we need to work in a bipartisan manner with the Secretary and solve the problems efficiently and focus, as the Secretary does, on helping students and not playing gotcha games with the Secretary. And I ask you, Madam Secretary, to commit again today to working faster and harder to get to the information requested and respond as quickly as possible so we can all be clearer and more direct about the concerns we have and whatever information we need. And Mr. Chairman, I'd say when requests go to the department, they be as specific as possible. And again, not trying to play gotcha games. Say, did you get this memo on January 10th written before you came into office? Those are the kinds of things that should be said instead of going on fishing expeditions. The Higher Ed Act does not prohibit the Secretary from providing partial relief for successful borrower defense claims. And I want to make an analogy here. I bet you there is not a member of this committee who's not had a car accident or a problem in homeowners insurance. And I'll guarantee you that the insurance companies don't write you a check for what you think is your damage. They assess that damage. They look at your car, they come to your home. What these members are saying is, you just write a check from the taxpayers and say, it's okay if you tell us you've been defrauded or you've been damaged. That's not the way it works. We've set the federal government up as the biggest loan institution in the country. Now we want it to be the biggest insurance company in the world, and that's just not right. What has been going on is nothing new. Regulations under President Clinton, President Obama, and now President Trump have all allowed for partial relief for successful borrower defense claims. The grandstanding today about unfairness could all be resolved if Congress had amended the borrower defense provisions in any of the HEA reauthorizations over the last 2 decades. If members of Congress don't like how much authority the statute has given the Secretary, then we should work together to amend the statute. No one has asserted that the Secretary has not followed the law. That's what oversight should be asserting, if that's what it is we're doing. And, Mr. Chairman, we disagree on policy a lot of times, but we don't disagree that students who represent not only our current situation in the nation, but our nation's future deserve all the opportunities to succeed. And frankly, I am saddened that I need to remind my colleagues of this. I think we need to respect this institution and honor it with the decorum that it deserves and show the students how we should behave and be examples for them. So thank you, Mr. Chairman, for your indulgence today.
Thank you. I want to thank the Secretary for your participation today. We've heard very valuable information. Members may have additional questions for you, and we'll submit them to you in writing. Remind the members that questions for the record must be submitted within 7 days, and the hearing record will be open for 14 days. I just want to say, finally, there's no question of whether partial relief is available or not, but in some of these cases, the fraud was so widespread, and the findings of the previous administration was that some of these degrees were absolutely worthless. University of Phoenix had a $191 million settlement for fraud. Nothing has been done so far on federal loans to provide that relief. We would think that if the fraud has been well established, that each person wouldn't have to come up individually to prove individual fraud. If there's such widespread fraud, I think the burden ought to shift to the business. And finally, a lot has been said about the Obama process. The memos that we have presented show that there was a process. They discharged loans for 28,000 borrowers and had a process that would have eliminated the backlog in a couple of months. As I indicated, we hadn't seen it. Obviously, we'd seen it. We hadn't seen them in the submissions, but we got those memos showing the process from the media, not from submissions. So we'd expect if we had gotten those earlier, we could have discussed them not as gotcha, but as part of the process. There's no further business to come before the committee. Without objection, the committee stands adjourned.